Oh, I'll take that.
Oh, he's cut his hair and fall off the mic.
That'll be there.
No, it's not. It's not.
Yeah, I heard. Yeah.
Call the matter for judgment, please.
NSD 103 of 2023, Bruce Lehrmann and Network 10 Proprietary Limited for judgment.
The judgment I'm about to deliver is 324 pages long. It will be published on the Federal Court website immediately following the pronouncement of orders. But given the public interest in the case, I intend to attempt to provide an oral overview of my findings and the reasons for the making of the orders I propose to make. Alas, even this oral summary will be lengthy because the case and the reasons have some complexity. I should note that these remarks are in explication, not supplementation of what I have written. Mr. Bruce Lehrmann sues Network 10 Proprietary Limited and Lisa Wilkinson in defamation in relation to an episode of Network 10's The Project program. It is a singular case. The underlying controversy has become a cause célèbre. Indeed, given its unexpected detours and the collateral damage it has occasioned, it might be more fitting to describe it as an omnishambles. For some I think I got up to the point where I said omnishambles. I was going to ask you, Dr. Collins, whether perhaps we should recall Mr. Reedy, the lip reader. For some people, any unwelcome findings will be peremptorily dismissed. The reasoning process, including the drawing of fine distinctions based upon the subtleties of the evidence, will be of no interest. This reaction is inevitable given that several observers have a Rorschach test-like response to this controversy and fasten doggedly upon the truth as they perceive it. Their response is visceral because the truth is revealed and declaimed rather than proven and explained. Some jump to predetermined conclusions because they are disposed to be sceptical about complaints of sexual assault and hold stereotype beliefs about the expected behaviour of rape victims, described by social scientists as rape myths. Others say they believe all women surrendering their critical faculties by embracing and acting upon a slogan arising out of the Me Too movement. Some have predetermined views as to the existence or otherwise of a conspiracy to suppress a rape for political purposes. For more than a few, this dispute has become a proxy for broader cultural and political conflicts. This judgment is not written for people who have made up their mind before any evidence was adduced or are content to rest upon preconceived opinions. It is written to set out my factual findings comprehensively and explain my decision to the parties and to the open and fair-minded. To achieve this end, and from the start of the case, I've attempted to ensure as transparent a process as possible, conscious that a trial conducted in public, accessible to the public, and only upon evidence and the submissions made fully available to the public was the best security for confidence of the fair-minded in the impartiality and efficiency of the justice system. An astute observer would have gleaned from the trial that this case is not as straightforward as some commentary might suggest. In part, this is because the primary defence hinges on the truth of an allegation of sexual assault behind closed doors. Only one man and one woman know the truth with certitude. For an impartial observer seeking to divine the truth, or more accurately ascertaining what most likely happened, two connected obstacles emerged. The first is, at bottom, this is a credit case involving two people who are both, in different ways, unreliable historians. Countless scholarly articles have been written seeking to explain the frailties of human memory and why it is that different people may remember the same event in different ways. People give unreliable evidence for various reasons, and distinguishing between a false memory and a lie can often be difficult. Aspects of so-called witness demeanour or physiological signs of deceit are of little use unless the witness is cognitively aware of their deception. Recognising these realities, judges are reluctant to characterise a false representation as a lie unless another explanation is unavailable and it is necessary to do so in order to resolve a controversy. But as we will see, this is a case where credit findings are central and sometimes an explanation other than mendacity is not rationally available. To remark that Mr. Lehrmann is a poor witness is an exercise in understatement. As I'll explain, his attachment to the truth was a tenuous one, informed not by faithfulness to his affirmation, but by fashioning his responses in what he perceived to be his forensic interests. Ms. Brittany Higgins, Mr. Lehrmann's accuser, was also an unsatisfactory witness who made some allegations that made her a heroine to one group of partisans, but when examined forensically have undermined her general credibility to a disinterested fact-finder. The second and related obstacle was the assertion that what went on between these two young and relatively immature staffers led to much more. By early 2021, allegations of wrongdoing had burgeoned far beyond sexual assault. It was said a sexual assault victim had been forced by malefactors to choose between her career and justice. The perceived need to expose misconduct and the institutional factors that allowed it meant the rape allegation was not pursued in an orthodox way through the criminal justice system, which provides for complainant anonymity. As we will see, when examined properly and without partiality, The cover-up allegation was objectively short on facts, but long on speculation and internal inconsistencies. Trying to particularise it during the evidence was like trying to grab a column of smoke. But despite its logical and evidentiary flaws, Ms Higgins' boyfriend selected and then contacted 2 journalists, and then Ms Higgins advanced her account to them and through them to others. From the first moment, the cover-up component was promoted and recognised as the most important part of the narrative. The various controversies traceable to its publication resulted in the legal challenge of determining what happened late one night in 2019 becoming much more difficult than otherwise would be the case. The substance of each matter is relatively identical, and Mr. Lehrmann says the project program, in its natural and ordinary meaning, was defamatory of him and carried imputations to the effect he raped Brittany Higgins in Defence Minister Lionel Reynolds' office in 2019. Network 10 and Ms Wilkinson deny the matters concern Mr. Lehrmann, but if they did, they admit the pleaded imputations were conveyed and are defamatory of him. I have no doubt Mr. Lehrmann was identified, and hence subject to the respondents making out any defences, he would be entitled to judgment. But in considering these defences, I first need to find facts. The judgment in section E sets out a number of legal propositions and principles by which I set out the approach to fact-finding, onus and the standard of proof. I will merely mention 3. This case is to be decided on the balance of probabilities. This is often misunderstood. It does not mean a simple estimate of probabilities. It requires a subjective belief in the state of facts on behalf of the tribunal of fact. When the law requires proof of any fact, the tribunal of fact must feel an actual persuasion of its occurrence or existence before it can be found, and a mere mechanical comparison of probabilities independent of reasonable satisfaction will not justify a finding of fact. This means the alleged rape will not be proven unless I feel an actual persuasion of its occurrence. But having said this, the difference between the criminal and civil standard of proof is substantive and can be decisive in dealing with the same underlying allegation. Apart from anything else, the difference is evident from the necessity that in a criminal trial, the facts as established must be such as to exclude all reasonable hypotheses consistent with innocence. Secondly, this is a case where there is a very large record of what occurred in real time. In addition to the file notes, text, social media messages and emails, hours of audio, video, CCTV footage has been adduced into evidence. I viewed this contemporaneous material and, for my manifold sins, have listened or watched all of the audio-visual records in evidence. I have trudged unyieldingly through this material because insofar as it casts light on the relevant issues, these contemporaneous records are a far surer guide as to what happened than ex post facto accounts or rationalisations or unverifiable assertions as to what people felt. Thirdly, moreover, in assessing whether one has reached a state of reasonable satisfaction in making a finding of fact, it is jejune to proceed on the basis that rejecting part of an account of a witness of an event must mean one must reject all aspects of the account of the witness. Consistently with ordinary human experiences, some witnesses may misremember or lie about some things and yet tell the truth about others. Despite my concerns about the truthfulness of both Mr. Lehrmann and Ms Higgins, it would be simplistic to proceed on the basis this means I must reject everything they say. Before coming to the facts, it's been necessary to make some observations given the centrality of credit to the proceedings as to the central witnesses. In section F of my judgment, I set out my general assessment of the creditworthiness of the evidence given by a dozen out of the total of 33 witnesses who gave oral evidence. I'll just mention a few. In another defamation case, I said that many experienced judges have expressed the caution that any criticisms of a witness which go beyond the legitimate necessities of the occasion should be avoided. Unnecessary credit findings should be eschewed. Part of this reticence reflects a body of research casting doubt on the ability of judges to make accurate credibility findings based on demeanour. But this is a case where several of the deficiencies were both patent and telling. Moreover, this is a case where credit, given the way it impacts upon the resolution of the determinative issues in the case, requires close and especially nuanced examination. Mr. Lehrmann. I will deal later with the account given by Mr. Lehrmann as to why he went back to the ministerial suite on the fateful night. I can make observations as to his creditworthiness by reference to other aspects of his evidence. Network 10 described Mr. Lehrmann as a fundamentally dishonest man prepared to say or do anything he perceived to advance his interests. Senior counsel for Ms. Wilkinson described him as an active and deliberate liar and wondered aloud whether Mr. Lehrmann is just a compulsive liar. Hyperbolic submissions made about the lack of credit of a witness are not uncommon. Justice Beach-Jones recently in a speech noted a judge should be reticent about accepting such submissions, open quotes, unless you really have to, close quotes. But even taking this wisdom into account, this is one of those cases where expressing criticism is warranted. But one must not be simplistic. A falsehood told by a witness will be especially serious if the maker is under a legal obligation to tell the truth. But irrespective of legal obligation, there are gradations of seriousness of untruths. An untruthful person may just be all mouth and trousers, or may be recklessly indifferent to the truth, or, by way of compulsion, finds it difficult to discern between what is true and untrue, and finally and most culpably, may be someone who tells calculated, deliberate lies. I do not think that Mr. Lehrmann is a compulsive liar, and some of the untruths he told during his evidence may sometimes have been due to carelessness and confusion, but I am satisfied that in important respects he told deliberate lies. I would not accept anything he said except where it amounted to an admission, accorded with the inherent probabilities, or was corroborated by a contemporaneous document or a witness whose evidence I accept. Instances of Mr. Lehrmann's false out-of-court statements or unsatisfactory evidence are legion, but I'll just indicate the following few examples. First, there was the evidence denying he found Ms. Higgins alluring as of March 2019. As I will explain, from the start, Mr. Lehrmann thought that Ms. Higgins was attractive. This attraction informed a number of his later actions. Moreover, his denial of this fact was unwary as it contradicted what he'd said on the Spotlight program. When confronted by this inconsistency, his attempt to explain it away by suggesting the attraction he felt for Ms. Higgins was just like the attraction I can feel to anyone else in this courtroom, irrespective of gender, was as disconcerting as it was unconvincing. Secondly, and relatedly, Mr. Lehrmann initially gave evidence he had not met Ms. Higgins prior to attending the Kingston Hotel on 2 March 2019 and downplayed his awareness of her. Thirdly, there was the false evidence about what occurred at the dock on 22 March 2019. Going back to the hierarchy of untruths referred to at the beginning of these remarks, this was an aspect of Mr. Lehrmann's evidence where I am unsure whether he was being recklessly indifferent to the truth or was finding it difficult to remember what was true or was confused or a combination of these things. Mr. Lehrmann must have known that the relevant CCT footage would be examined by some with the intensity that others analysed the Zapruder film. Hence, even if one was willing to give false evidence, it was odd to dissemble as to these matters. There was an inevitability that the CCT footage would demonstrate A, he had purchased drinks for Ms. Higgins and seen her consume significant quantities of alcohol. B, his prior explanation for how he paid for the drinks would not pass muster. And C, he spent most of the evening with Ms. Higgins. Even if one puts the best complexion on what occurred, it confirms that Mr. Lehrmann's evidence is unreliable. Fourthly, there is the evidence as to what occurred at the Canberra bar 88 MPH. Mr. Lehrmann emphatically denied any intimacy with Ms. Higgins at 88 MPH. This evidence was not only false, as I will later explain, but was in tension with representations he'd made to the Australian Federal Police. As I'll come to, Ms. Lauren Gaines' account that she observed Ms. Lehrmann and Ms. Higgins, open quotes, being quite touchy with one another, and her memory of them both engaging, open quotes, in a passionate kiss, close quotes, and of Ms. Higgins, open quotes, taking selfies of two of them, close quotes, was compelling. It also reveals the hollowness of Mr. Lehrmann's suggestion that his relationship with a girlfriend morally inhibited him from engaging in intimacy with Ms. Higgins. This was an example of Mr. Lehrmann being mendacious about a centrally important part of the case. Fifthly, as detailed at great length in the judgment, Mr. Lehrmann gave false evidence about a litany of other matters, such as being reprimanded by Senator Reynolds, the classified documents security breach as to securing entry into Parliament House, the circumstances in which he came to be accompanied by Ms. Higgins when securing entry, about whisky, and about his representations made to Miss Brown. All these falsehoods, together with his Walter Mitty-like imaginings in skiting to Miss Gain about ACES, demonstrate that Mr. Lehrmann has no compunction about departing from the truth if he thought it was expedient. I'll now deal with what I describe in the judgment as the spotlight detour. The conclusions expressed in the preceding section had been drafted prior to Easter Sunday. Following a reopening, reasons for which I set out in the judgment, Mr. Taylor Orbach, a former senior producer on the Spotlight program, was called to establish the propositions that 1, to the extent of what might be described as collateral rewards given to Mr. Lehrmann for his cooperation with the Seven Network were more extensive than had previously been stated, and 2, contrary to various assurances given, Mr. Lehrmann provided material to the makers of the Spotlight program contrary to his subsisting legal obligations. I deal with each topic below, but it's worth initially making 2 points. First, Mr. Orbach accepted in cross-examination that he hated his former colleagues and former friend, Spotlight producer Mr. Steve Jackson, blaming him in part for the fact his contract at the Seven Network was not renewed. Given his cast of mind and his more general resentment as to how he was treated over the Spotlight program, it is unsurprising he has an animus towards the Seven Network, and this was manifest in his evidence and in his manner of giving it. His resentment was palpable upon the viewing of the wanton and vaguely disturbing destruction of what appeared to be a perfectly serviceable set of golf clubs. It's unnecessary to make factual findings in relation to many aspects of his evidence, but one would generally be cautious in making findings based upon incomplete evidence and resting solely upon the word of a man motivated by such rancour. Secondly, in connected with my first point, the evidence of Mr. Orbach travelled beyond seeking to impeach the credit of Mr. Lehrmann. He laid the allegations on thick against a variety of persons, somewhat like the paint in an early work of his namesake, Frank. One of these allegations was that he was instructed, apparently implicitly by a solicitor, Mr. Richard Keegan, to delete any materials that could be damaging for Seven. I reject this assertion. It is unbelievable on its face. As to his allegations of improper conduct against his erstwhile work colleagues, they are irrelevant to the facts in issue except in one limited respect. I can deal with Mr. Orbach's evidence of profligate behaviour very briefly. He gave evidence consistent with contemporaneous documents and uncontradicted by any evidence in reply by Mr. Lehrmann that he became Mr. Lehrmann's babysitter or minder as the Seven Network worked to secure an exclusive interview with Mr. Lehrmann. At some stage it appears Mr. Orbach was discomforted in being placed in this role, but he nonetheless performed it, sometimes it appears ardently. I assume that Mr. Lehrmann thought his joint activities with Mr. Orbach would be kept private. The specifics are unedifying and it is unnecessary to make granular findings. In the end, it is fair to conclude that Mr. Lehrmann was less than candid in his account of the extent of the benefits he received prior to and in exchange for his bargain to participate in giving exclusive interviews to the Seven Network. It is fair to remark that the evidence reveals is that some of the pre-compact inducements and consideration flowing in the direction of one contractual counterparty was of an unorthodox and undocumented kind. But given the other matters going to credit in this case, it is an inconsequential point. The second point has more significance. For reasons I set out in detail, and notwithstanding the fact that I'm not some sort of roving law enforcement official and that any alleged breach of the Hernan Street obligation, if it is to be pursued, will not be by me and will not be by this court, I am satisfied that Mr. Lehrmann made or caused to be made false representations as to the topic of providing access to documents the subject of a subsisting legal obligation to the Seven Network. Ms. Higgins. It is necessary to assess the credit of Ms. Higgins circumspectly. She is someone who has had the intense uncritical support of some, but has also been the subject of widespread social media abuse. As with Mr. Lehrmann, I'm conscious that giving evidence would have been a daunting and stressful experience. I am in the unusual position of receiving submissions from a witness as to her credit directly. This came about because I was anxious to ensure procedural fairness was provided concerning submissions made as to the falsity of certain out-of-court representations. Ms. Higgins' submissions extended beyond these out-of-court representations, and there was one point also made by the respondents that is worth mentioning. That is, it is said that to the extent that so-called peripheral details of her reconstructed memory were wrong, they do not reflect dishonesty, even though they may raise an issue as to reliability. As to reliability, one must not take account of the well-known features of human memory, but also the mental state of Miss Higgins and the well-known specific effect of trauma, and in particular sexual assault, on her memory. This submission has merit up to a point, and it has informed my consideration of important, indeed critical aspects of Miss Higgins' evidence. But as I will explain, I am comfortably satisfied that a number of the credit issues arising from a fair assessment of Miss Higgins cannot be minimised in this way. Those studying political science in the late 20th century were inevitably introduced to the work of Hannah Arendt, who discussed the importance of public truth while coining and explaining the notion of organised lying. There is a significant difference between the distortions of Mr. Lehrmann and Miss Higgins. In the case of Mr. Lehrmann, the untruths were all over the shop, being a form of what might be described as disorganised lying, whereas the untruths of Miss Higgins, A, can be placed in two temporal categories, B, were in the latter category quite organised, and C, within both categories, generally had a common thread. In 2019, this was to paint aspects of her conduct in a better light at a time when she did not wish to pursue a complaint, but by 2021 and afterwards, most were part of a broader narrative or theme that she and her boyfriend wished others to believe, and it appears others wanted to believe. Unsurprisingly, counsel for Mr. Lehrmann made several detailed attacks on the credit of Miss Higgins in final submissions, but no distinction was recognised between the two periods and the different contexts I have described. Miss Higgins was described as a fundamentally dishonest witness, such that the court could not act on anything she says without independent corroborative evidence. This submission was developed by asserting her evidence has been so discredited and has been shown to be so manipulative that the court cannot safely rely on anything she has said. Like with Mr. Lehrmann, I will not evaluate her evidence as to what occurred in the ministerial suite now, but it's convenient just to note some points made by Mr. Lehrmann. In fact, there were 10 primary points made in the submissions, which I deal with really in the course of making findings of fact. I'll only mention 2, which I think are inconsequential at this stage. Mr. Lehrmann submitted that Miss Higgins' draft manuscript was full of inaccuracies and inconsistencies with her evidence, and her unsatisfactory excuse that the book is crap, notwithstanding she was under a contractual obligation to tell the truth in the manuscript, reflects upon her credit. And finally, Mr. Lehrmann relies on what he described as Miss Higgins' misleading and dishonest claims about a lack of forensic analysis of Mr. Lehrmann's phone in her speech to the media after the mistrial, when she well knew that Mr. Lehrmann's phone has been analysed by the AFP. It's convenient, as I say, to deal with these 2 points shortly. They are not of real significance. As to the book, as the saying goes, an autobiography usually reveals nothing bad about a writer except his memory. I propose to focus on representations made on more solemn occasions than those appearing in a draft of what by its very nature is a self-serving account. As to the final point, senior counsel for Mr. Lehrmann suggested, not unfairly, that these factually inaccurate comments reflect a broader aim of Miss Higgins to engage in commentary to shape the public relations narrative from 2021, to draw attention to what she and her supporters consider to be the unfairness of her account being scrutinised or questioned in any way. But the speech was given at a highly emotional time, and it does not seem to me to be of much present relevance. Then I deal with what I describe and collect together as 2019 conduct issues. Consistently with what I've identified as the temporal differences, the matters insofar as they involve Ms Higgins' conduct immediately after the incident 2019, leading to a submission that Ms Higgins' evidence has been so discredited that the court cannot safely rely on anything she said, not only puts the point much too highly, but is simplistic. There are inconsistencies and untruths in 2019, but they must be contextualised. Additionally, there is a lack of nuance and superficiality of dismissing a witness as always untruthful or unreliable just because aspects, even important aspects of their evidence, fall into that description. Moreover, given the potential agreed effects of trauma, I do not consider any of this 2019 conduct or any other of the alleged counterintuitive conduct referred to in the judgment, such as her email contact with Mr. Lehrmann, as necessarily inconsistent with a victim of sexual assault seeking to process what had occurred, working her way through feelings of confusion, questioning her conduct, considering what she should do, and reflecting on how people would perceive her if she made a complaint. In making these comments, I'm not discounting the important untruths Ms Higgins told the AFP in her 2019 interactions with them. These require extended consideration they receive in the judgment. But in the end, I consider they are examples of Ms Higgins, then under stress, but decidedly uninterested in pursuing a formal complaint, trying to develop an account she could rationalise and perceived her made look better in the eyes of others. It was the numerous aspects of the conduct of Ms Higgins in the years following to 2019 that were far more troubling. The most important aspect of this later conduct, commencing in 2021, was the way in which Ms Higgins crafted a narrative accusing others of putting up roadblocks and forcing her 2 years earlier of having to choose between her career and seeking justice by making and pursuing a complaint. As we will see, the articulation of the core aspects of this claim commenced shortly before Ms Higgins' boyfriend, Mr David Shiraz, made the necessary arrangements for Ms Higgins to tell her account. She did this to Ms Maiden, leading to the Maiden article, and to Ms Wilkinson, and then to Mr Llewellyn, and through them to those that worked on the project program. As I will explain, what is notable about this aspect of the account of Ms Higgins is not only its inconsistency with contemporaneous records and its falsities, particularly as to Ms Higgins' dealings with Ms Brown, but also its imprecisions and its reliance upon speculation and conjecture. Eschewing specifics and primarily concentrating on her alleged feelings rather than the actions or words of others, the initial recounting of the project team on 27 January 2021 had Ms Higgins use the highly ambiguous word weird, or variations such as people were acting weirdly no less than 82 times. The same nebulous word in some grammatical form was also used 34 times during the much shorter interview with Ms Maiden. Although there are differences, what Ms Higgins said to Ms Maiden is broadly the same as that conveyed to the project team, and the credit point is sufficient to be made by reference to those latter representations. In the febrile atmosphere of 2021, many instinctively believe what Ms Higgins asserted about the rape and the subsequent cover-up of the crime. In advance of any trial where the rape allegation would be examined, the broader allegations of Ms Higgins, resulting in being feted by many, becoming a celebrated speaker at a mass demonstration, becoming nominated for awards, receiving invitations to make a nationally televised speech at the National Press Club, and a book deal with Penguin Random House apparently worth $325,000. Further, the allegations relied upon, together with other things, in support of several claims for compensation asserted to be, open quotes, variously available against the Commonwealth of Australia as Ms Higgins' employer, and in addition to other employees of the Commonwealth and the Honourable Senator Reynolds, the Honourable Senator Cash, the Commonwealth and the Liberal Party. More particularly, these claims involved the allegation that following her reporting a sexual assault, she suffered victimisation, including ostracism and being pressured not to discuss the assault, or the Commonwealth, the then Prime Minister and Senator Cash and Reynolds' handling of it, and workplace bullying and harassment. Ms Higgins' claims were compromised after the initial trial and the terms set out in a deed of settlement and release between her and the Commonwealth of Australia, as represented by the Department of Finance on 13 December 2022. Despite the submissions of Mr Lehrmann, I do not consider I should place any significant weight on the fact that Miss Higgins asserted in evidence before me and before the Commonwealth deed was produced that the Commonwealth came to an agreement that a failure of duty to care had been made. Given the quantum paid by the Commonwealth, as a layperson, she might have come to believe the Commonwealth must have accepted the underlying merit of her factual and legal claims. Similarly, although Miss Higgins understated the amount the Commonwealth paid to her benefit, this is again perhaps understandable, as like many litigants, she was no doubt focused on the net sum she was able to pocket following the payment of disbursements. What is of more importance is the Commonwealth deed provided A, an express warranty was given by Miss Higgins that the matters referred to in the Commonwealth deed are true and correct. B, the warranty as to truthfulness was given with the intention of inducing the Commonwealth to enter into the Commonwealth deed. C, for an acknowledgement the Commonwealth was relying upon this and other warranties given by Miss Higgins. D, and the Commonwealth was to pay Miss Higgins, or for her benefit, the total sum of $2.445 million as compensation in respect of claims potentially available to Miss Higgins under the Australian Human Rights Commission Act, the Sex Discrimination Act and the Disability Discrimination Act. That is, in broad terms, the payment was made for any potential claim under defined statutory cause of action and was given in exchange for releases, except that those releases did not extend to releasing Senator Reynolds and Senator Cash from any actions that do not relate in the performance or non-performance of their ministerial duties or fines or penalties. I stress that Miss Higgins is not a party, no findings in this proceeding bind her, and of course no relief is sought in this proceeding in relation to the Commonwealth deed. It is not my role to comment upon the merits or otherwise of the statutory causes of action made against the Commonwealth or others, the nature or quantum of the compensation sought, the process by which the settlement occurred, nor the quantum of the resolution sum or scope of releases. My focus is solely upon Miss Higgins' present creditworthiness. As Annexure E reveals, submissions were made on this topic of credit as it related to the Commonwealth deed, consistently with the express agreement of the parties. I initially thought in its written submissions Network 10 was backsliding and flirting with the contention it would be procedurally unfair to make findings as to the falsity of representations made by Miss Higgins in the Commonwealth deed, but I was disabused of my misapprehension in supplementary submissions, and Network 10 further acknowledged that any false representations made in the Commonwealth deed could be relevant to the credit of Miss Higgins. One would have thought that this was an obvious and proper concession given the nature of the occasion upon which the representations were made, but it is now also necessary to deal with separate submissions made by Miss Higgins, which I deal with in some length in the judgment. To repeat, I do not consider it necessary nor appropriate that I attempt to characterise or reach any legal conclusion as to Miss Higgins' conduct in giving the warranties contained in the Commonwealth deed. I'm only dealing with issues as to credit. It is sufficient to find that through her personal injury solicitors and more likely than not on instructions, Miss Higgins was in 2022 advancing a claim for compensation based on allegations materially the same as she had articulated to Ms. Maiden and the project team, the core aspects of which she had consistently maintained since at least January 2021. More specifically, representations materially identical to the central representations made in the Commonwealth deed had been made for almost 2 years and now were being used to ground the statutory cause of action articulated by her solicitors. The Commonwealth deed is useful in going some way in collecting, formalising and providing some belated degree of coherent particularisation of what might broadly be described as the cover-up allegation. In this regard, and contrary to the submissions of Network 10, the relevant issue is not whether Miss Higgins made representations in a manner consistent with her evidence, but rather whether Miss Higgins made representations contrary to the facts. It is evident that several things being alleged were untrue. As my findings below will establish, and without seeking to be exhaustive, I set out a number of matters in the representations where they are contrary to the facts. In doing so, I don't include examples where the underlying falsifying proposition was not put to Miss Higgins, nor have I placed any significant weight on incorrect but relatively minor inaccuracies. The third aspect of the post-2019 conduct causing concern relates to Miss Higgins' so-called bruise photograph. The bruised photograph was said by Ms Higgins in her statutory declaration or on oath as being record of an injury suffered during the rape, and hence being contemporaneous documentary evidence supporting her accusation. Indeed, as we will see at the beginning of the first meeting with the project team, the photograph is raised specifically by Mr Shiraz and Ms Higgins as the only evidence that elevated Ms Higgins' account from simply being one person's word against another. Its forensic importance is manifest, and while she was under an obligation to tell the truth, it was put forward by her as corroborative material. Despite this, Ms Higgins distanced herself from embracing it as evidence of the rape in the evidence before me. In the witness box at this trial, she seemed irritated that the cross-examiner would challenge her on the photograph, but the evidence as to her inconsistencies on this topic are both important and vexing. As we know, the original photograph, despite its obvious importance, was not mentioned or provided to the AFP in 2019. This is despite Ms Higgins meeting a few days after the bruised photograph was supposedly taken, with highly experienced AFP sexual assault investigators sensitively asking her for any relevant information over a lengthy period in the presence of a sexual assault counsellor providing her with support. Further, the metadata of the original photograph has never been produced. The earliest record of the bruise or the photograph is in 2021, and when this reproduction is examined, it shows a bruise on Ms Higgins' right leg in circumstances where she gave evidence that Mr Lehrmann had crushed her left leg during the alleged rape. What is equally odd are the singular circumstances by which Ms Higgins' phone was completely wiped and her photos disappeared from her iCloud records, and yet the bruised photograph and some other limited material survived, allowing it to be deployed by Ms Higgins and Mr Shiraz to lend verisimilitude to the account that she gave to Network 10. I go into considerable detail into this topic in the reasons, but it suffices for present purposes to note that despite her evidence before me, I consider it unlikely there could be genuine confusion in Ms Higgins' recollection as to how she got the bruise recorded in the bruise photograph, given the way she and Mr Shiraz deployed it in 2021 and their subjective understanding of its importance. Nextly and relatedly was the missing messages, including one on the morning she left the ministerial suite with a security guard and with Miss Hamer, Major Irvine and Ms Gain, including tellingly Exhibit 47 being a deleted text message automatically saved separately in the notes section of her phone, whereby Ms Higgins, on 27 January 2021, and just after the 5-hour conversation with Ms Wilkinson and Mr Whelan, sought to prompt Ms Gain as to a detail of Ms Higgins' narrative of what occurred in 2019. Also missing was the important and truthful message to Mr Dillaway on 9 April 2019, in which Ms Higgins tells Mr Dillaway that she was, open quotes, not interested in pursuing, close quotes, a police complaint. Moreover, the missing data went beyond text messages but included photos taken on the night in question which may have shown interactions between Ms Higgins and Mr Lehrmann. This is in circumstances where A, the evidence establishes that Ms Higgins had been asked by Detective Senior Constable Sarah Harmon on 8 April 2019 not to delete photos taken on the evening, including photos Ms Higgins had said she had taken of her and Mr Lehrmann on 22 March. B, it is evident from CCTV footage from the dock that Ms Higgins had taken photographs at the dock. C, Ms Gain gave evidence of Ms Higgins having taken selfies at 88 MPH at around the time that Ms Higgins and Mr Lehrmann were being intimate. And D, the AFP did belatedly access Ms Higgins' phone on 26 May 2021, and approximately 8,000 photographs were downloaded, but they did not include any photographs taken by her on the fateful night. Finally, there's an example of an untruth in what, in the overall scheme of things, might be thought inconsequential but was revealing. Ms Higgins asserted that Nick, her bumble date, left the dock because he was, open quotes, bullied mercilessly by everyone at the event. They were all poking fun at him and laughing at him, and pretty quickly he was driven out of the event. But what the CCTV footage irrefragably proves is that no one did anything that could be remotely described as bullying Nick. Ms Higgins abandoned her date as she preferred to go and sit at the same table as Mr Lehrmann. Ms Higgins, after being taken to the video, had to accept, or be in what at the time struck me as a curiously light-hearted tone, that I did ignore my date and I was really rude. Although on one level minor in itself, this untrue representation is one example of a willingness to make an accusation cut out of whole cloth because it suited Ms Higgins to make it. I will come to other examples below, including a substantively more important one relating to Mr Payne recounted to Ms Maiden. These are my concluding remarks on general credit. When closely analysed, Ms Higgins' out-of-court representations in 2019 are of a different character than those out-of-court representations in 2021 and in court thereafter. Any inconsistent or untrue representations in 2019 are not inconsistent with the conduct of a genuine victim of sexual assault, struggling to process what happened, seeking to cope and working through her options. But whatever the truth of the evidence she gave as to what occurred in the ministerial suite one night in 2019, the cogency of her evidence as to this central aspect of the case must be evaluated and closely scrutinised in the light of the fact that my findings established that since 2021, Ms Higgins, 1, made false representations as to what occurred following the incident to Ms Maiden and the project team and more generally thereafter. 2, asserted definitively that she retained contemporaneous evidence of the rape that she knew bolstered her credibility and rely upon it, when on the most generous view of it, it ought to have been apparent to her as she recognised at this trial there was an infirm basis for doing so. 3, selectively curated material on her phone prior to giving it to the AFP. And 4, sometimes told untruths when it suited her. In summary, and having had the opportunity of observing Ms Higgins' demeanour closely over approximately 4.5 days and comparing her testimony to other documentary and oral evidence I accept as being cogent, it would be fair to describe her as a complex and in several respects unsatisfactory witness. Nuance is required in evaluating her evidence, and any contentious and uncorroborated aspect needs to be scrutinised warily. Ms Brown. Both Mr Lehrmann and Network Brown subpoenaed Ms Brown to give evidence and foreshadowed calling her in their case. Mr Lehrmann did so. The respondents contend it's important not to overstate the significance of Ms Brown's evidence because her management of the allegations in March 2019 is not in issue, save to the extent it has a bearing on the assessment of Ms Higgins' credit. They do, however, embrace aspects of Ms Brown's evidence. Despite this, Network 10 says the evidence of Ms Brown has to be treated with some caution because it is said she made selective and not literally contemporaneous notes. She professed recollection of matters not recorded in her notes. She had a general tendency to understate the obvious significance of what she had learned about the incident, and it is difficult to accept her evidence that sexual intercourse or sexual assault had been committed, and it was something that she could not rule in, could not rule out. Ms Wilkinson makes a submission. It's open to the court to form the view that Ms Brown is not being dishonest about her insight as to what she had learned about the incident, but rather completely lacks ordinary human insight into such matters, perhaps because she lacked training in what was peculiarly called general human experience. I had the opportunity of closely observing Ms Brown giving evidence over 2 days for approximately 5 hours, without any intended disrespect or, I hope, stereotyping. Ms Brown struck me as the archetype of a successful professional administrator of a certain age and disposition. She had a conservative outlook and conducted herself in a careful and generally risk-averse way. Despite having her health seriously affected by allegations of shameful conduct, and like the other principal actors, experienced a torrent of social media abuse, she gave evidence in a calm way and was responsive to questions. One aspect of her evidence was particularly striking. Despite Ms Brown facing sustained pressure from her minister and one of the minister's colleagues to report the incident to the AFP, even though she was then unsure an allegation was being made of rape, and irrespective of the wishes of Ms Higgins, she pushed back. She was not someone to speculate or jump to conclusions, and I reject any suggestion Ms Higgins expressly said to Ms Brown at either their first or second meeting that she had been raped or sexually assaulted. As Ms Higgins later said to Ms Maiden, "I don't know, I think for the longest time I was really weird about actually saying it was rape." Ms Brown did not draw a definite conclusion in the light of the ambiguous words used by Ms Higgins. She adopted the more cautious view that sex and something untoward may have happened. But what does not reflect caution was standing up to her minister and the chief of staff of another minister when Ms Brown thought that they were intent on protecting their own interests at the expense of allowing a young woman to make her own decision as to whether she would involve the police, even at some risk to her professional career. This showed integrity in resisting pressure she subjectively considered inappropriate and evinced a concern for the autonomy and welfare of Ms Higgins. in these circumstances, to be later vilified as an unfeeling apparatchik willing to throw up roadblocks and covering up criminal conduct at the behest of one's political overlords must be worse than galling. The attempts in cross-examination to impeach the integrity of Ms Brown's contemporaneous notes went nowhere. The contemporaneous records support the notes being prepared when and how Ms Brown said they were prepared. They do not purport to record everything, but only what was regarded to be the key points. They are, like in so many cases where there is an honest and careful note-taker, the best record of the dealings they document rather than later recollections. I reproduce them as an extra B to my reasons. And I find to the extent that they record the dealings of Ms Brown, they are accurate and reliable. Further, to the extent there is a conflict between those notes and the evidence of Ms Brown and that of Mr Lehrmann, I unhesitatingly prefer the evidence of Ms Brown. The same goes for any conflict between the evidence of Ms Brown and the notes with that of Ms Higgins. Indeed, in assessing the critical evidence of Mr Lehrmann, as I explained at length in the reasons, aspect of Ms Brown's contemporaneous notes which did not receive particularly close attention at trial are of signal importance, in that they record Mr Lehrmann's initial responses to queries made of his actions by Ms Brown. Importantly, as to his activities in the ministerial suite on the fateful night, he represented A, he did not access any documents, B, he came back to drink whiskey and ended up drinking 2 glasses, C, he chatted with Miss Higgins but didn't wish to get into anything else they did, D, they, that is Miss Higgins and Mr Lehrmann, had a whiskey, and E, Miss Higgins was happy when he left and he said he had to go home and said bye, see you next week. He said he had to get home. Returning to Miss Brown, she may not have been schooled by health and psychological professionals in dealing with sexual assaults, and may not by reason of her personality and age been as empathetic to some others or have the acute sensitivity of some millennials. She no doubt could have done some things differently. For example, even though Miss Higgins did not raise it at the time, the unprompted failure to recognise the inappropriateness of holding the initial meeting with Senator Reynolds in the Minister's office was maladroit. But wherever shortcomings can be identified, including with the benefit of hindsight, she ensured she took considered advice from those in whom she reposed confidence, recorded and acted upon that advice, and subject to the above showed common sense and compassion by her own lights, demonstrated by all her contemporaneous records, including text messages. Despite the express and implied criticism of her, Ms Brown went out of her way to reassure Miss Higgins and supported her and assisted her in contacting the police. It is worth noting that the AFP officers Ms Brown assisted Miss Higgins in seeing promptly are, even now, described by Miss Higgins as being wonderful and were really lovely to me, amazing and great. As Ms Brown herself put it, she did her professional best with what was given to her. If one wants to get a real reflection of the contemporaneous 2019 views of Miss Higgins, well before the attitude of Miss Higgins towards Ms Brown evolved in 2021 consistently with the development of the broader narrative of a cover-up, they are reflected in her text message of 7 June 2019. I wanted to say this in person, but I cannot overstate how much I valued your support and advice throughout this period. You've been absolutely incredible and I'm so appreciative. I also deal at some length with the evidence of Ms Gain, Major Irvine, Mr Payne and Mr Dillaway. They are all important witnesses. They are all the recipients of contemporaneous representations made to them by Ms Higgins, which assume some importance in the reasoning. I'll deal briefly with Ms Wilkinson's evidence. Ms Wilkinson's evidence did not lack self-assuredness. As one would expect from someone with her professional background, Ms Wilkinson was a polished and articulate witness. Regrettably, however, these not inconsiderable skills were often deployed by her in the witness box to advocate for her views. Her counsel made the point, not unfairly, that Ms Wilkinson has spent decades in a professional environment which involved conversation-style interviews and debates, and in these circumstances it was unsurprising she had a difficulty within the structure of giving evidence for the first time in court. This submission may have some merit because when she gave evidence for the second time at the trial, she was a candid and far more responsive witness. Be that as it may, and notwithstanding allowances for her background as a presenter, some aspects of her initial spell in the witness box caused me concern. For present purposes, it's worth mentioning 4. First was her refusal to make the obvious concession in response to her cross-examiner's questions that her speech at the 67th Annual TV Week Logies Award on 19 June 2022 conveyed the message that Ms Higgins was credible and to be believed, and therefore by necessary implication that her allegation of rape was true. This was a speech given by a proposed Crown witness 8 days before a criminal trial was due to begin during a televised program broadcast in the Australian Capital Territory. I then refer to the reasons of the Chief Justice of the Australian Capital Territory and her measured and pointed criticisms. But despite these, when the topic of the speech was canvassed in cross-examination, Ms Wilkinson took comfort in A, the fact she did not say in express term that Mr Lehrmann was a rapist and that she was only celebrating her courage. B, the Chief Justice had acted on the basis of an incorrect representation that Ms Wilkinson had received a warning about possible consequences of the proposed speech by the Director of Public Prosecutions. And C, she had taken legal advice from Ms Tasha Smithies, the Senior Litigation Counsel for Network 10, and the speech was made with the encouragement of Network 10. As to A, as Ms Wilkinson eventually and inevitably conceded, by necessary implication she was celebrating Ms courage in making a true allegation of rape. And as to B, it was common ground before me that no warning was given by Mr Drumgold, and this is consistent with the evidence of Ms Wilkinson and Ms Smithies. As to C, it emerged belatedly during the hearing that Ms Wilkinson was correct in saying Network 10 through Ms Smithies did provide express advice as to the giving and content of the speech. Ms Kat Donovan, the Network 10 head of PR, who had seen an advance copy, had led Ms Wilkinson to believe that Network 10 had given full approval, and consistently with that encouragement, that evening at 11:07pm, Ms Beverly McGarvey, the Chief Executive Officer of Network 10, acclaimed Ms Wilkinson for having given what Ms Garvey described as a beautiful speech. It will be necessary to return to aspects of this conduct that can be attributed to Network 10 below. What became apparent by the end of the evidence was that the action in giving the speech was not, as many had suggested, a case of Ms Wilkinson going off on a frolic and irresponsibly saying something off the top of her head. She was sufficiently prudent to seek advice. She only came to give the speech as a result of being badly let down by those to whom she turned for advice and counsel. One can well understand Ms Wilkinson's frustration at the true picture being obscured by Network 10 maintaining its joint claim for privilege until the 11th hour. But although the reality of this advice and encouragement provides important context, Ms Wilkinson was a Fourth Estate eminence grise of over 40 years' experience. She gave evidence she was appointed a member of the Order of Australia in 2016 for, among other things, service to broadcast and print journalism. If she had thought matters through as an experienced journalist, and less as a champion for Ms Higgins, she ought to have known the speech was fraught with danger and recognised that lauding a complainant on the evening of a rape trial in the terms she did would be apt to undermine the due administration of justice. She was keen to give the speech not because of pressure from her employer, as seems to be suggested by her final submissions, but because, in the words of Ms Smithies, Ms Wilkinson had become inextricably entwined with Ms Higgins and had provided her with clear and unequivocal support in the preceding 18 months. The speech was part of a continuum of conduct of Ms Wilkinson celebrating and lending credence to Ms Higgins as a woman of courage whose story must be believed. I accept Ms Wilkinson did not fully appreciate the extent of the problem, given the advice and encouragement of Network 10, and perhaps because the approbation of the speech received by way of applause from her professional peers on the night, notwithstanding some of them surely must have been aware of a pending rape trial. But in the end, what matters for present purposes is less the lack of judgment in giving the speech, but rather a lack of candour in the witness box by refusing initially to admit it conveyed the representation that Ms Higgins' rape allegation was credible and to be believed. I disagree with the submissions made on behalf of Ms Wilkinson that the questions of the cross-examiner were imprecise. The evidence illustrated a tendency of Ms Wilkinson to avoid making concessions, even an obvious one. Secondly, some of her evidence about the content of the project program displayed an allied tendency to make assertions that she thought supported her case but lacked a factual foundation. One notable example was the evidence that an aspect of the project program conveyed the notion that Ms Brown was caring, or that aspects could be construed as complimentary about Ms Brown or Senator Reynolds. Counsel for Ms Wilkinson defended specific answers relating to Ms Brown at some length in written submissions, But the notion that the project program was not very critical of Ms Brown as well as Senator Reynolds is utterly unsustainable. Her evidence also embraced the concept the project program conveyed to viewers that Ms Higgins was putting pressure on herself not to go to the AFP, rather than alleging she was experiencing such pressure from Ms Brown and Senator Reynolds. Self-created roadblocks were put up, the argument apparently goes. Not only is that wrong on any objective review of the broadcast, but as disingenuous as the contemporary observations that the participants demonstrate, and as I set out at great length in the judgment. A further example of the making such assertions was her evidence in chief that every new piece of information which came to her attention prior to broadcast corroborated Ms Higgins' version of events. She stood by this evidence in cross-examination, notwithstanding she admitted she'd read prior to broadcaster communications from what she described as, open quotes, some nameless person in the Prime Minister's office, close quotes, providing a contrary account. She dismissed this material as a very official response to the very difficult political situation the government was in. In a similar way, according to Ms Wilkinson, she had been told by Mr Llewellyn at some point that the reason for the loss of data from Ms Higgins' mobile phone related to transfer from multiple mobiles. There is no contemporaneous record of this communication, and given its obvious importance, this lack of record is intuitively surprising. But assuming it was said, this information was inconsistent with what Ms Higgins had earlier said about her alleged loss of data. How this corroborated Ms Higgins' version of events rather than undermined her credibility on a topic considered at the time by Ms Wilkinson to be important was unexplained. Thirdly, was her willingness on affirmation to double down on an allegation that Ms Brown and Senator Reynolds were active participants in a systemic cover-up of alleged criminal conduct when, on any fair review of the available material, the basis for such a grave allegation is infirm, even taking the evidence of what Ms Higgins as to what she felt or what was weird, and her assertion senior staffers from the Prime Minister's office had met with Senator Reynolds in her office at their highest. The willingness to maintain such a conduct occurred in the absence of any solid verifiable material in her possession. Just demonstrates her willingness to engage in speculation or, to use her words, read between the lines. Indeed, the maintenance of this allegation seems odder in circumstances where by the end of the trial Ms Wilkinson was emphasising her reliance on the investigative work of others. In any event, for the purposes of assessing her evidence, this willingness to speculate causes me to approach her testimony with some caution. Fourthly, and picking up on the last point, there is the evidence upon which rests Ms Wilkinson's final submissions that her job in relation to the publication was to, open quotes, read the pre-prepared script, close quotes, and open quotes, she not only acted reasonably in reading the pre-prepared script, but perfectly in that she read it for word, close quotes. As I develop at length in the submissions when dealing with the reasonableness of her conduct in relation to publication, this picture is hard to reconcile with Ms Wilkinson getting up on the night of the Logies, accepting a prestigious award on behalf of the project and declaiming, "This interview and story is by far the most important work I have ever done." Moreover, the evidence as to any degree of professional scepticism or rigour in analysing the allegations must be seen in the light of her assertion immediately thereafter, "I knew it. That is, it would be the most important work I would ever do," from the very first phone call I had early last year with a young woman whose name she told me was Brittany Higgins. Balanced against this is that I accept Ms Higgins was sincere and genuine in parts of her evidence, and most particularly consistently with what she said at the Logies, she never questioned the underlying truth of any of Ms Higgins' allegations from the first moment they were ever articulated. I also accept she held genuine concerns about the procedures and assistance available to Ms Higgins as to what she alleged she experienced. In particular, I accept she fully believed what Ms Higgins told her on 2 February 2021 about the state of Senator Reynolds' knowledge as at the time of the 1 April meeting. I also accept Ms Wilkinson reposed confidence in the producers and executive producers at Network 10, who were responsible for different aspects of the production, editing and approval of the project program. I deal also with Mr Llewellyn and Mr Meakin and other witnesses, but I will pass over them for present purposes. Logically, one would then come to the truth defence, but the respondents say that even if they are unable to prove substantial truth, they have a complete defence. It's convenient to briefly deal with these defences, the most important of which I deal at length in sections J and K of my reasons and it relates to whether the conduct of Network 10 and Ms Wilkinson in publishing the matter in its character of conveying the defamatory imputations of rape fell short of the standard of reasonableness. Looked at it from the perspective of both respondents, I find it fell short of this standard for a number of reasons. Summarising them, 1. The rape allegations were intertwined with the cover-up, and the project team had strong indications of the unreliability of their main source, particularly as to how she lost material on her phone and selected material survived. Her explanations were implausible, and rather than this being a flashing warning light, Mr Llewellyn's instinct was to avoid, open quotes, unnecessary doubt, close quotes, and was not even followed up. The lack of curiosity about investigating the bruise photograph is especially unreasonable given its subjective and objective importance, and given it was said to viewers to be physical evidence corroborating Ms Higgins' rape allegation. 2. Further relevant to credibility as to the allegation of rape was the fact that her account was full of inconsistencies and implausibilities. A fair review of the first meeting reveals to an objective observer how vague Ms Higgins was as to any concrete detail, repeatedly asserting that people or things were weird or saying what she felt, and to the extent there was any detail, those details shifted, rather than this resulting in reasonable scrutiny of her general credibility. These matters were passed over. Thirdly, the motivations of Mr Shiraz in selecting the journalist to tell and use the story were manifest, and rather than this motive being a cause of some degree of circumspection, Mr Llewellyn and Ms Wilkinson indicated their willingness to assist in the political use of the allegations as Ms Higgins and Mr Shiraz intended. Fourthly, there was no proper investigation of representations made of the timeline document, including as to why it was said notification was sent to the DPP from Parliament House AFP station, an allegation never explained. The tension between the notion there was something sinister about the ominous comment about contact with Minister Cash from the Star Chamber being rejected, with the fact that Ms Higgins in truth was offered 3 jobs after the 2019 election, the wrongful implication that Mr Lehrmann was fired because of the assault, and finally Ms Higgins' assertion that she met with the Parliament House AFP on 26 March, which was not only wrong factually but necessarily confused the fact that Ms Brown organised the initial visit after the meeting on 1 April. Fifthly, the ahistorical and misconceived notion embraced by Mr Llewellyn and Ms Wilkinson that about unchecked parliamentary power and that 2 elected politicians were the ones who granted police access to Parliament House sounded bizarre and anachronistic, and Mr Llewellyn's thought, oddly, that he was in Charles I territory. I say oddly because the only sovereign to revoke civil war by executive overreach was not exactly open to assertions of parliamentary power. The view of Ms Wilkinson that the system of policing within Parliament House was archaic led to the conclusion that the AFP operated at the directive of parliamentarians themselves, and no one was independently policing potentially criminal behaviour within Parliament House. It's apparent Mr Llewellyn and Ms Wilkinson were operating on the basis that in substance there was a political managed approach to policing within Parliament House, such that it was open to members of the executive to interfere with how the AFP went about their job investigating crime. From this dangerous notion, it was a short step to embracing the idea that any delay in securing CCTV footage must be suspicious, rather than being the regular product of the need to obtain permission of the presiding officers. Together with the other things Ms Higgins was alleging, that, according to Ms Wilkinson, made Parliament House the safest place in Australia to rape someone. Sixthly, the approach to seeking comment from Mr Lehrmann, including the steps taken to contact Mr Lehrmann, from which approach there was no dissent by Ms Wilkinson, when the contacts provided by Mr Shiraz were obviously inadequate, and the project's team were warned not to research Mr Lehrmann via LinkedIn in case Mr Lehrmann was notified of the research. If Network 10 wanted to get in contact with Mr Lehrmann, there were ways of ensuring that contact could be achieved. He was not living the life of a hermit. He was working for a public relations company in Sydney. This approach lacked reasonableness in the circumstances of the publication of an allegation of such seriousness. Network 10 were not to know that Mr Lehrmann was unlikely to take up invitation. Finally was the dismissal of contradictory information received from Mr Carswell and failing to follow it up with Ms Higgins. But this is a mere instance of the broader problem that Mr Llewellyn, like Ms Wilkinson, started from the premise that what Ms Higgins said about her allegations was necessarily true. They resolved from the start to publish the exclusive story and were content to do the minimum required to reduce unacceptable litigation risk. I then go to the factual findings of relevance to the Section 25 substantial truth defence. I set out in exhaustive detail through the judgment the pre-incident defence relating to the Reynolds office, Mr. Lehrmann's knowledge of Miss Higgins, what happened on 2 to 3 March 2019 drinks at the Kingston Hotel and related events, the 15 March 2019 Team Reynolds dinner, on 20 March 2019 Mr. Lehrmann's first security breach, and then I'll start in my summary with the events on 22 March 2019 before the dock. On 22 March, Mr. Ben Couch, an aide-de-camp, messaged a group of friends within the Department of Defence and adjacent offices, including a number of aides-de-camp from the Royal Australian Navy, arranging a plan for drinks at the dock around 7 p.m. Miss Higgins was invited along separately with Miss Gain, whom he had known for a couple of months. She viewed the event as a networking opportunity and a chance to demonstrate to her professional peers that she wasn't just a receptionist and she had contacts. Miss Higgins extended the invitation to a number of others, including Mr. Wenke and Mr. Lehrmann, and a man she was in contact with on the dating application Bumble, who also worked in politics. Miss Higgins' hapless state was referred to initially as Bumble Guy, but was later given the dignity of being known by the name Nick. Miss Higgins went home to ready herself for the night ahead. She had worn her favourite white pencil dress to work that day with a cardigan to make it more office appropriate. She swapped her cardigan, work bag and work items, including her parliamentary pass, for a smaller handbag and had a glass of wine before catching a taxi or Uber to the dock. Quite separately, Mr. Lehrmann and Mr. Wenke made plans to have a couple of beers and a bite at the Kingo after work. Unconvincingly, Mr. Lehrmann told the court he recalled Austin and I were working on something and he could not recall if it was necessary to go home after the Kingston return to Parliament, while Mr. Wenke was clear, and I accept, he had finished work for the week by the time he set off for the Kingo. There is no record of Mr. Lehrmann telling his girlfriend of his plans. At some point over the course of their repast or afterwards, Mr. Lehrmann and Mr. Wenke decided to accept the invitation to kick on to the dock. Fortunately, we can identify with some precision what went on at the dock, given the existence of what Mr. Reedy just correctly described as high quality and clear CCTV footage. Over an extended period, it shows a group seated together around a long table, variously chatting, mingling, drinking, tucking away pizza and chips and going to the bar and moving to and fro. Miss Higgins arrived at about 7:19 p.m. and was greeted by a group of 8, including Miss Gain and Major Irvine, who had each arrived slightly earlier. Mr. Wenke's evidence was that he and Mr. Lehrmann arrived at the dock around 8 or 8:30, but the CCTV records the group at the large courtyard with Mr. Lehrmann and Mr. Wenke arriving at 8:39 p.m, at which time Miss Higgins was in conversation with Nick. Mr. Lehrmann agreed that the image recorded him and Mr. Wenke arriving at the dock. After being introduced and exchanging pleasantries with those at the large table, Mr. Lehrmann and Mr. Wenke went inside to the bar to order their first round and then went to the courtyard and sat at a smaller table at around 8:44 p.m. Miss Gain was seating with them. Miss Gain had not previously met Mr. Lehrmann, and she asked him where he worked. Mr. Lehrmann told her that he was at Senator Reynolds' office, and at some point in the conversation, Mr. Lehrmann spun the tall tale of he was waiting on a clearance to come through so he could get a job and work at ACES. Miss Gain politely kept her well-founded incredulity to herself. Not much time passed when Miss Higgins entered into the courtyard at 8:51 p.m. with a drink in her hand and joined a conversation about the previous federal election and the imminent poll with Mr. Lehrmann, Miss Wenke and Miss Gain. Nick, alas, was left chatting to a man in a blue shirt. After being forsaken like a shag on the rock for an extended period and despite making successful attempts to interact with some of the group at the larger table, Nick understandably left the dock, no doubt ruining swiping right. With the exception of Mr. Lehrmann, no one who gave evidence as to their time at the dock could recall discussing Australia's submarine contacts with France at either table. The lack of recollection of any discussion of this topic is intuitively unsurprising. Declaiming on the topics of who was building submarines and where they were being built is not quite the repartee one would usually expect to hear over a convivial drink on a Friday night between 20-year-olds out for a good time, even if, with respect, one would not expect the badinage of the Algonquin Round Table and that some attending were political junkies who had an interest in defence matters. The lack of detailed conversation on this topic is also consistent with Mr. Lehrmann's evidence that he was aware he could not discuss sensitive matters in private and so kept the conversation at the dock friendly and social. There are only three things that I will deal with by way of summary, although the various other events at the dock are set out in great detail in the reasons. That is, Mr. Lehrmann's payments, the drinks consumed by Miss Higgins, and a summary of the interactions between Miss Higgins and Mr. Lehrmann. Miss Lehrmann's payments. The CCTV establishes beyond argument what happened, and inevitably Mr. Lehrmann was required to accept the answers he had given about not having bought drinks for anyone other than Mr. Wenke had been false. How then did he purchase them? The answer can be seen in the portion of the CCTV footage which demonstrates that at about 9:35 p.m, Mr. Lehrmann handed over a card in payment of a $42.50 charge for a round of drinks, one of which is for Miss Higgins. Despite his persistent representations to both the AFP and this court that he only had access to the cards in respect of which he provided statements, this is untrue. This issue was essentially ignored in Mr. Lehrmann's written submissions, with the comment being made that Mr. Lehrmann's evidence about the number of drinks purchased at the dock was less problematic than it was made out to be, because it was not just him who was clearly wrong about various details, and he had no reason to retain minute details of this night and was unrealistic to expect him to do so. But it is much more than that. This is far from a picayune point. I do not accept that having access to another source of funds to allow payment by way of the dock and possibly later at 88 MPH is a minute detail or is something that would have been forgotten. Moreover, Mr. Lehrmann did not say he may have had access to other funds and could not now recall. He repeatedly denied it. The purchase of drinks on behalf of Miss Higgins by Mr. Lehrmann was and must have been known by Mr. Lehrmann to be an important aspect of their interactions leading up to the incident later that night. Drinks consumed by Miss Higgins. There was no agreement and hence no comprehensive table provided by the parties in their final submissions about what the evidence reveals as to all the drinks consumed by Miss Higgins on the evening of 22 March and the early hours of 2019. I prepared such a table and set it out in my reasons, and I find that by the time they left the dock, Ms. Higgins had consumed 11 drinks, including the 10 drinks consumed by her at the dock. Including 6 drinks, Mr. Lehrmann observed Ms. Higgins consumed. Mr. Lehrmann made a number of submissions about the caution in making those findings, but doing my best from viewing the CCTV footage and the other evidence, I find Ms. Higgins had the drinks I've identified, and I do not accept Mr. Lehrmann's submissions. But if for some reason I'm wrong and only 9 drinks were consumed, I don't think this really matters, because it's not possible to be precise as to the full extent of her further consumption, and she continued to kick on. Then the third aspect of what happened at the dock that I'll deal with is the interactions between Mr. Lehrmann and Miss Higgins. In final submissions, Mr. Wybrow contended that if one has regard to the whole of the CCTV footage rather than select extracts, it's not accurate to say Ms. Lehrmann is spending all his time with Miss Higgins, plying her with drinks, etc. It is true that Mr. Lehrmann was not constantly with Miss Higgins and was not encouraging her to drink earlier in the evening, but it is equally true that his evidence in chief that his interactions with Miss Higgins at the dock were professional and cordial, and that I recall them being minimal to extent, was a very serious distortion of their dealings. Those interactions cannot be characterised, as Mr. Lehrmann attempted to do, with some brief social interactions or incidental conversations or nothing of substance. Contrary to his evidence, he did spend most of the evening with Miss Higgins, and as the night wore on, he was aware of her drinking, and towards the end of the evening was encouraging her to drink well beyond the grounds of sobriety. He was also keen to continue the evening and his interactions with her As events at the dock were winding up, a plan was made for a group to then go to an 80 themes bar known as 88 MBH located at Canberra Civic. 88 MBH. As it happened, only Mr. Lehrmann, Ms. Higgins and Ms. Wenke and Ms. Gain continued on to 80 statements. But Ms. Higgins did get evidence Mr. Lehrmann and Mr. Wenke bought her and Ms. Gaines drinks and they were shots. Although she could not recall how many shots she had, her recollection were that there were rounds of drink, plural. Ms. Gaines said she could remember having at least one drink, and Mr. Wenke explained he could recall talking and drinking but could not recall the specifics. It is not entirely clear, but I think it's highly likely that Ms. Higgins had at least 2 and possibly more shots at 88 MPH given the context of the earlier drinking, particularly towards the end of the festivities at the dock, Mr. Lehrmann's encouragement of the drinking, and the solecism of taking the benefit of shouting and not reciprocating. This is consistent with Ms. Higgins' evidence and suggests that she had at least 2 shots. I'm fortified in this view given the group stayed at 88 MPH for a period in excess of an hour and a half. But whatever else may be less than pellucid, one thing did emerge with clarity from the evidence of Ms. Gain, that at 88 MPH, Brittany hooked up with Bruce. I am amply satisfied that I ought reject the evidence of Mr. Lehrmann and Ms. Higgins, which was inconsistent with the account of Ms. Gain. In particular, I reject Mr. Lehrmann's denial of pashing Ms. Higgins and any intimate behaviour with Ms. Higgins at 88 MPH. As to Ms. Higgins, she asserted that Mr. Lehrmann was all over her space and then gave certain evidence I set out. Ms. Higgins' evidence that she was passive and discomforted is an example, on one level understandably, of Ms. Higgins moulding her recollection. Despite her evidence, as much as Ms. Higgins might regret it, as Ms. Higgins recalled, as Ms. Gain recalled, they were quite touchy with one another, and her hands were on her thighs and her hands were on his thighs, and they were engaged in a mutually passionate kiss. This was a, quote, real kiss, close quotes, more than, open quotes, a peck. It was very much a kiss, close quotes, a, open quotes, passionate kiss, close quotes, and a, open quotes, pash, close quotes. The submission made by Network 10 that Ms. Gaines' account is entirely consistent with Ms. Higgins' account is with respect silly. One does not pash passively. Ms. Higgins was acting upon his attraction to Ms. Higgins, and the less than sober Ms. Higgins was sufficiently uninhibited to be a not unwilling participant in the level of intimacy Ms. Gain described. Any discomfort was not evident to Ms. Gain, who viewed what was happening as mutually intimate conduct by 2 young people hooking up in a nightclub. I also accept the evidence of Ms. Gain that Ms. Higgins fell over and was required to be helped back up. This happened close to the booth, and Miss Lehrmann was the one to help her back into the booth. Ms. Gain also told the court she formed the view based on a previous observation of alcohol on Ms. Higgins that Ms. Higgins was intoxicated. She knew the difference between Ms. Higgins was and was not drunk, and she characterised Ms. Higgins as drunk at 88 MPH. I accept that this was her genuine view, informed by observing her over an extended period that night, and this view accorded with the reality of Ms. Higgins' condition. Leaving 88 MPH on the journey to Parliament House. By about 1:30 a.m, the group resolved it was time to go. Ms. Gain and Mr. Wenke agreed to share an Uber or taxi as they lived in the same direction. Ms. Gain could not recollect leaving 88 MPH. Ms. Higgins' present recollection was that someone told her that she and Mr. Lehrmann lived in the same direction, and by that stage she was, open quotes, so compliant, close quotes, that she agreed and got into a cab or Uber with him. Mr. Lehrmann's evidence was that everyone left 88 MPH at the same time, and that he indicated to the group that he had to go back to Parliament House to get his keys. He further asserted that Miss Higgins indicated that she needed to go to Parliament House, and consequently he suggested that they should share an Uber. I reject both these accounts. Mr. Lehrmann's account is risible. Ms. Higgins was the most junior and recent member of Senator Reynolds' office. What possible reason was there for this heavily intoxicated young woman, who had earlier seen no need to carry her parliamentary pass, to go back to work after a night on the tiles? It is not as if one can readily envisage what work was necessary to be done by a junior media advisor at a ridiculous hour on a Saturday morning. Further, if the reason Mr Lehrmann needs routine to Parliament House was to collect his keys, he could have texted his girlfriend and have her meet him at the door or called her. Mr Lehrmann asked me to accept the proposition it was, open quotes, a process to get in, close quotes, to his shared flat, and that to avoid this complication, he preferred to A, go out of his way to go back to work in the early hours, B, lie to Parliament House security, C, sign the necessary register, D, be issued with a pass, E, go through a medical detector, F, be escorted by a security guard to his office, G, obtain the keys from his office, H, book another Uber, I, go back through a parliamentary exit, J, meet a ride-share car, and K, ride home. Even if he was in the doghouse because he'd stayed out late, I think it's safe to conclude that the process of getting into a flat he shared with his girlfriend would have been a significantly less elaborate exercise. Moreover, the incoherence of this evidence is shown by the fact that if he really needed to collect his keys from Parliament House, he could have just said so, and the sensible security guards who gave evidence before me would no doubt have assisted him to get them. Miss Higgins' evidence was that she thought she was going home. She said at some point during the ride, Mr Lehrmann had said something to the effect, "I have to just pick something up from work," close quotes. This account has a kernel of truth, and it explains why she agreed to leave with Mr Lehrmann, or even explains why she got into the Uber with Mr Lehrmann, but otherwise does not withstand analysis. Like with so much fact-finding in litigation, the key to unlocking what most likely happened is to be found and examine the most contemporaneous accounts. In this case, what they both initially and spontaneously said as to why they ended up in an Uber and going back to Parliament House. As is set out in the judgment, for Mr Lehrmann, this comes from a conversation with Ms Brown in their second meeting on 26 March 2019, when he told her that he, open quotes, came back to drink some whiskey or something like that, close quotes. Notably, and as I've already explained, at this meeting, after Mr Lehrmann said he chatted with Ms Higgins, when pressed by Ms Brown's question, "What else did you do when you were in the office?" Ms Lehrmann revealingly said he didn't wish to get into that. As for Ms Higgins, as I have referred to in dealing with the credit of Major Irvine earlier in the reasons, on the Wednesday or Thursday after the incident, Ms Higgins said to her, open quotes, "Bruce and I were in an Uber to go home and he wanted to come back to Parliament House. He had some whiskey to show me or something," close quotes. This is also consistent with her representation to Mr Dillaway on the day of the incident, despite at the time being cagey, that we brought the party back to Parliament House. I'm satisfied that regardless of whether there was any settled initial plan to share an Uber home at some stage, and with the acquiescence of the inebriated Ms Higgins, the plan became for the Uber to go to Parliament House following what Mr Lehrmann had said about whiskey. Needless to say, based on this finding and the evidence she gave at trial, the representation by Ms Higgins that it was without agreement that she came back is incorrect. Then I deal with what I describe as a snapshot of time, things we know about the position at 1:40 a.m. I previously commenced a defamation judgment by referring to saw that nothing good happens after 2 o'clock in the morning, and observing it reflected the wisdom that drink in the wee hours often occasion trouble. Here too there was a combination of drink in the wee hours, and it led on any view of it to trouble. But before we examine what that trouble entailed, it's worth pausing to consider what was likely in the minds of one man and one woman who found themselves being conveyed by an unknown Uber driver to Parliament House shortly before 22 in the morning. Dealing first with Mr Lehrmann. He had been attracted to Miss Higgins for a while, and for the first time he had just been able to kiss the object of his attraction passionately, placed his hand intimately on her leg and thigh, and had his physical displays of affection requited. Secondly, as is reflected by what had just taken place, he was a man who had already acted unfaithfully towards his girlfriend by the standards of right-thinking people, and had no scruples about doing so again that evening. Thirdly, he likely wanted to continue to be intimate with Miss Higgins. Put bluntly, he was a 23-year-old male cheating on his girlfriend, having just hooked up with a woman he found sexually attractive. Human experience suggests that what he then wanted to happen is not exactly shrouded in mystery. Fourthly, Mr. Lehrmann had been drinking and he knew Miss Higgins was inebriated. Indeed, as I have explained, he had encouraged Miss Higgins' consumption of alcohol, and although he may not have understood precisely how alcohol affects the cerebral cortex of the brain and works to impair cognitive and psychomotor functions, like most young men, he must have known that excessive alcohol consumption leads to impaired judgment and lowered inhibitions. Fifthly, he could not go to his place for obvious reasons, and if he wanted to continue to be intimate with Miss Higgins, he knew this was best done at a place he could access and where they could be alone. Of course, he knew such a place, being the Minister's office at Parliament House. Sixthly, he would have been buoyed by getting Miss Higgins into the Uber and securing her agreement to come back to the ministerial suite by telling her something along the lines of that he had some whiskey to show her or something. Seventhly, he would have thought the presence of whiskey in the ministerial suite made it a perfect location, and a better option than suggesting going back to Miss Higgins' shared accommodation, as Parliament House afforded the opportunity of continuing to drink whiskey, which would only assist his aim of continued or enhanced intimacy. Incidentally, this probably meant his comment about seeing his whiskey had a broader significance than just being Mr. Lehrmann's functional equivalent of a cliched pickup line used by men of ill intention to lure women to a private place. Eighthly, in the light of the above, common sense suggests that it is obvious there was one dominant thought running through the mind of Mr. Lehrmann as he was approaching Parliament House, and it had nothing to do with French submarine contracts. Then we have Miss Higgins. She was in a very different and potentially difficult position. She was working in a professional office where she correctly perceived Mr. Lehrmann as having greater power, and in fact he had been dealing with her as a subordinate. Earlier in the evening, she felt Mr. Lehrmann was nice to me for the first time, and I was pleased with how it was going, and felt like an equal, and they were peers almost. She wanted to get on with him, and moreover was keen to interact, even at the expense of abandoning her date. She was drunk and had been drunk for some time, and for whatever combination of reasons, she not only rebuffed the advances of Mr. Lehrmann, but had reciprocated in the manner described by Ms. Gain. Given the state of the evidence, apart from the uncertainties of trying to draw conclusions from what one can gauge impressionistically from the parliamentary CCTV footage, how keen Miss Higgins was to go back to Parliament House is difficult to tell. But even if she found the prospect a tad unwelcome, going back was understandable, as like many professionals the subject of an advance by a work colleague with more power, Miss Higgins did not want to alienate someone she perceived could be of real importance to her career. If she agreed to go back somewhat reluctantly, it would have been for a reason not dissimilar as to why she made light of the incident 3 weeks earlier, when Mr. Lehrmann had taken her mobile phone and as she was trying to leave the Kingo. In this regard, there is no evidence Ms. Higgins was aware that Mr. Lehrmann had already decided to move on from working for the minister. In any event, she agreed to go back to Parliament House after Mr. Lehrmann had said he had some whiskey to show her or something, but the extent of her genuine enthusiasm and whether in her affected state she thought she was going back for a drink or whether she thought the reference to whiskey was simply a pretext for more intimacy is difficult to tell and in the end does not really matter. Notably, Ms. Wilkinson submits that it may be, having regard to Ms. Higgins' interactions with Mr. Lehrmann at 88 MPH, that it was Ms. Higgins' intention to have sexual intercourse with Mr. Lehrmann at that time, and she no longer recalls that given her level of intoxication, and this would be one explanation as to why she exited with Mr. Lehrmann at Parliament House rather than staying in the Uber and going home by herself. It is also worth noting, before going on, a number of the above matters bring into sharp focus the central importance of my findings based upon the acceptance of independent evidence of both Ms. Gain as to what occurred earlier in the night and Major Irvine being the recipient of a recounting by Miss Higgins of what occurred around 4 days later, and, as I will explain, are consistent with the other representations made by both Mr. Lehrmann and Miss Higgins in the immediate wake of the incident. Security and entry into the ministerial suite. Upon arrival at the gate to the entry into Parliament House, Mr. Lehrmann pressed the intercom and said, "Oh, hi mate, Bruce Lehrmann here with Minister Reynolds. We've been requested to pick up some documents. I've forgotten my pass." I emphasise the word where because at the trial it was often said I've been requested, but it's clear upon listening closely Mr. Lehrmann uses the word where, we've. The reason for this lie, according to Mr. Lehrmann, was that if he had suggested his reason for returning to Parliament House was to collect his keys, security would have thought it was a minor thing and told him to bugger off and come back next week. I did not accept this speculative evidence, and notably this suggestion was never put to the security guards for their comment. A further flaw in Miss Lehrmann's account is that although he says he thought Miss Higgins had some unarticulated reason to access Parliament House, he never ascertained whether she had a security pass or a better reason to enter, which would have obviated his reason to lie. Miss Higgins recalled getting out of the car and walking to the Point 8 entrance to the back of Parliament House. She says she could not recall why she had got out of the car, but gave the evidence that she just thought because Mr. Lehrmann had got out, she should too. But I do not accept this evidence. As I've explained, she knew she was going to the ministerial suite and had acquiesced in doing so. At around 1:41 a.m. on 23 March 2019, Mr. Lehrmann and Miss Higgins came into Point 8. Miss Higgins could not remember much conversation between her and the security guards. The evidence of one of the security guards, Ms. Nicola Anderson, was that she paid particular attention to Miss Higgins because she thought she looked nice, and she noticed she had what appeared to be a grass stain down one side of her dress. She also recorded in her later incident report that she was advised that Mr. Lehrmann and Miss Higgins had urgent business they needed tending to. The evidence of the other security officer, Mr. Mark Fairweather, was that he had previously seen Mr. Lehrmann and Miss Higgins at Parliament House, but he did not know their names, and that Mr. Lehrmann told him, "We're here to do some work," and that Mr. Lehrmann and Miss Higgins had to go to Senator Reynolds' suite. Mr. Fairweather was able to confirm relevant details as to Miss Lehrmann and Miss Higgins from computer records, but they were required to fill out a visitor's pass register, and Mr. Fairweather's evidence, corroborated by CCTV footage, was that Mr. Lehrmann completed the register for himself and Miss Higgins. Bizarrely, Mr. Lehrmann denied signing the register on behalf of Miss Higgins, but accepted that at no point Miss Higgins is recorded as bending down to write anything on the visitor's pass register, as seemed to be initially suggested by Ms. Anderson. One does not need the assistance of an expert to be confident the handwriting of the register is the same for both relevant entries. Mr. Fairweather recalled the general smell of alcohol, but did not think the visitors were overly affected, by which he meant slurring, falling over, or vomiting level drunk, so as to be refused entry. He considered the scale of intoxication to be very moderate, not heavily intoxicated, because otherwise he would have refused entry. Mr. Fairweather, although an experienced security guard, was not a breathalyzer in human form. He said at the time they were half pissed. I have no doubt evidence was given generally, but without prolonged examination and complete information as to what occurred in the evening, and although Mr. Lehrmann may only have been half pissed, he mistakenly but honestly underestimated the extent of intoxication of Miss Higgins. Similarly, Miss Anderson realised Miss Higgins was intoxicated after she observed her struggling to get her shoes back on and coming through the metal detector, and later recorded this observation on her incident report. I pause to note the trenchant criticism of Miss Anderson and Miss Fairweather in the submissions of Network 10 as both unfair and over the top. Those submissions censoriously assert that Miss Lehrmann and Miss Higgins ought to have been denied entry to Parliament House having regard to their state on arrival, or they ought to have been supervised when going to the ministerial suite and then immediately escorted out, and the security guards are open to criticism, and letting them in was a very serious misjudgment on their part. These prim criticisms were never put to them for their comment, and as anyone with the life experience of being in pubs frequently would understand, drunk people are often able to compose themselves for fleeting or short interaction, and it's often difficult to form an immediate and accurate view as to the extent of intoxication of a person with whom one has not had extended contact. I have little doubt that what happened with staff obtaining entry that night was no different than what would happen if staff presented themselves in the same way at entry points of countless professional offices throughout the country. On the information the security guards had available to them, they had no concerns that something untoward was going to happen. After having the benefit of hearing them in the witness box, I have no doubt the security guards were conscientiously trying to do their jobs, and the submissions critical of them, which smack of both hindsight distortion and Grundyism, ought not be accepted. In any event, Mr. Lehrmann and Miss Higgins then proceeded to put personal items into trays and went through the security scanner. Mr. Lehrmann walked through the metal detector and Miss Higgins followed him. The metal detector was activated twice by Miss Higgins, and Miss Higgins realised the culprit was Miss Higgins' shoes. Miss Higgins then returned through the medical detector and removed her shoes. She put her shoes in a white tray and pushed the tray through the scanning machine. She came through the medical detector without wearing her shoes, and it was not activated. The CCTV then records Miss Higgins making unsuccessful attempts to put on her shoes. Miss Anderson then said, "Don't worry about it. Just carry your shoes. It's okay, but put them on when you get up there." Miss Higgins then collected her items from the tray and hurried through a set of doors towards the lift. I have no doubt that Mrs. Higgins' inability to put on shoes was caused by her state of inebriation. This is consistent with her working barefoot through Parliament House and tossing her head back and looking towards the ceiling while she waited to be led into the ministerial suite. Miss Anderson then escorted Mr. Lehrmann and Miss Higgins to the ministerial suite, which they had opened with a key. Next, whisky and the accounts of what happened inside the ministerial suite. I set out great length in the reasons, the precise accounts given by the witnesses concerning what happened. But prior to do so, for the purposes of this summary, it's worth noting about whisky that I'm satisfied that, being the conscious of the importance of whisky, Mr. Lehrmann has made several false statements about this topic. I don't propose to recount Mr. Lehrmann's account, which is set out in the reasons. I'll simply move to what I say about it. I've already said enough to indicate that I consider Mr. Lehrmann's account to be an elaborate fancy. First, there are my findings as to what happened at 88 MPH and the rationale given by Mr. Lehrmann to have Miss Higgins come back to a private place at Parliament House. As I've already noted, put in stark terms, it's fanciful a somewhat lubricated male staffer accompanied by a woman he found attractive who had just been pashing in a nightclub despite having a girlfriend would then be interested after coming back to a private place very late to just say cheerio and then soberly proceed to note up briefs for a question time that was not to occur for 1.5 weeks, a fortiori when the staffer had already resigned, had no outstanding tasks, was not ordinarily involved in work concerning the defence portfolio, and hitherto had demonstrated no outward signs of being a workaholic. Secondly, even if we leave to one side my findings as to what was on Mr. Lehrmann's mind, the account itself lacks coherence. Ms. Lehrmann was unable to identify any information he obtained at the dock or 88 MPH relevant to the work he was supposedly doing for the Minister on the question time folders. Thirdly, and although less significant, Mr. Lehrmann did not mention being so conscientious he decided on work on question time folders early on Saturday morning when asked what he was doing by Ms. Brown, or when he was later asked to show cause as to why he should not be terminated for serious misconduct by the Minister. Mr. Lehrmann did not explain why he had not raised his supposed diligence other than he thought Ms. Brown would have been more concerned about someone coming back to the office doing work. Although I appreciate Ms. Brown would have escalated the security breach in the event Mr. Lehrmann had accessed sensitive work information, if Mr. Lehrmann had in truth been working manually in recording important information, one assumes there would have been ways of painting this information more favourably than coming back to the office for no reason rather than to luxuriate while imbibing strong liquor. Fourthly, it's not lost on me that doing manual marking up work on paper with a pen, moving documents around or sticking tabs on paper is perhaps the only work that would not require Mr. Lehrmann to log into a computer and leave some form of retrievable electronic record. I do not believe I'm being unduly cynical to remark this strikes me as being convenient. Fifthly, it may be a minor point in the scheme of things, but if we are to assume that Ms. Lehrmann had shared an Uber with Ms. Higgins and understood she was attending to some unexplained work task early on Saturday morning, why would Mr. Lehrmann just bolt from the office after attending to his task without attempting to extend the courtesy of checking whether she was there or saying he was going? One would expect a man with any manners faced with the possibility he was leaving a young woman late at night and unaccompanied, who he knew had been drinking, would check whether she had gone and, if not, how she was getting home safely. But it suffices for present purpose to say Mr. Lehrmann's account as to this aspect alone is intuitively odd. Sixthly, and importantly, there is a contradiction between this account and what he first told Ms. Brown before there was any allegation of sexual assault. As I have repeatedly noted, he first represented to Ms. Brown he did not access any documents, he came back to drink whisky, and he had a whisky with Ms. Higgins. All in all, I accept the submission made by Network 10 that Mr. Lehrmann's evidence about writing on question time folders was a transparent lie, and yet it remains the only explanation Mr. Lehrmann has offered to the court for his presence in the ministerial suite for 40 minutes on 23 March 2019. It's also unsurprising Mr. Lehrmann made his spontaneous and telling comment noted early to Miss Brown a couple of days later when asked, "What else did you do while in the office?" Mr. Lehrmann replied, "I don't want to get into that." Miss Higgins' account. Set out Miss Higgins' account at much length. Miss Higgins has no recollection of being escorted in the ministerial suite and did not even know there had been a security guard accompanying her and Mr. Lehrmann. Her first memory within the suite was sitting on a ledge, being a ledge by the windows overlooking the Prime Minister's courtyard. In any event, for reasons that were unclear in her inebriated state, she was apparently alone for some period, in the evidence described as either a really long period, or a long time, or 5 minutes, or it just felt long, or it was a minute, and she did not understand where Mr. Lehrmann had gone and why he was still at Parliament and wanted to go home. In her account in chief before me, her memory is then blank. She had said to Ms. Wilkinson that she was feeling very out of it, and so I got to the point where I ended up lying down and passing on the minister's couch. She also had said similar things to Ms. Maiden. Ms. Higgins at trial denied she remembered, that is, had a mule memory of laying down on the minister's couch in the private office. And although the above extract has a degree of tension with this evidence, before me, her evidence after being on the ledges, the next thing she knows is that, or the next touch point is that when she wakes up on the minister's couch. I'll not set out the graphic account of Ms. Higgins' evidence. I'll come to the consideration of the account of Ms. Higgins. The first thing to be said about Ms. Higgins' account is that it involves a grave allegation by a witness with general credibility problems and whose contentious evidence, in accordance with the fact-finding principles I've explained, must be approached with great care. But by reference to my findings as to the circumstances in which Mr. Lehrmann and Miss Higgins found themselves, taken as a whole, it does not strike me as inherently implausible, unlike the account of Mr. Lehrmann. Before drawing conclusions as to the extent to which this account should be accepted, 3 matters merit particular focus. This was despite these matters not being the subject of detailed submissions from Mr. Lehrmann because of the case theory of no contact adopted by him. First, as my findings establish, Ms. Higgins' account commences with a false characterisation of how it is she came back to the ministerial suite in the first place. As Ms. Gain made plain, she had hooked up with Mr. Lehrmann, and what occurred thereafter must be viewed in the light of the fact that Miss Higgins had been at a nightclub being intimate with Mr. Lehrmann and had agreed to accompany him. Secondly, and relatedly, is the pretext of coming back being what Mr. Lehrmann had said to her about whisky. She did not accompany Mr. Lehrmann to the suite just to sit passively on a ledge for a long period or a short period or something in between for no apparent reason, waiting for a person who had wandered off, unless, of course, it was to grab whisky and some glasses, a task which would have taken no time at all. Thirdly, and in a quite different category, is a subtle tension between Miss Higgins' various accounts of the assault. As I said at the commencement of the reasons, the surest guide to what went on are the probabilities arising from the logic of events, the testimony of independent and honest witnesses, and contemporaneous and apparently candid representations. Falling within the last 2 of these categories is the evidence of 2 assertions made by Miss Higgins, being 1, a representation made only 3 days after the incident and immediately after Mr. Payne had asked, "Did he rape you?" being her immediate and spontaneous response, "I could not have consented, it would have been like fucking a log." And 2, with her boyfriend, her ex-boyfriend, again just days after the incident, where in response to his direct question, "Did you hook up in there or did someone take advantage of you?" Miss Higgins replied, "Yeah, it was just Bruce, and from what I recall, I was barely lucid. I don't feel it was consensual at all." These representations, which suggest she was passive and hence incapable of consenting, reflect an interaction somewhat different from one where Miss Higgins had repeatedly, unequivocally, as she said in evidence before me, said no on a loop. This must be qualified by noting that consistently with the notion of passivity, there was alleged immobility, and that she also said at trial, as I've reproduced in the judgment, that she couldn't scream for some reason. It was just like trapped in my throat. I couldn't do it. I know I felt really like waterlogged and heavy, and I couldn't move. And later, I couldn't like scream like you in the horror movies, like I couldn't, I don't know why I couldn't. In pointing this out, I'm conscious that shortly after the incident on 1 April 2019, Miss Higgins told AFP officers that Bruce had said something about finishing. I said something about no or no don't. As I'll explain, however, this was said by Miss Higgins while she was conveying a number of untruths to AFP officers, which seemed to paint her actions in what she at the time perceived to be a better light at a time when she was not intending to proceed with a criminal complaint. That is perceived. What is one to make of this? It might have been said to be a possible pointer to a lack of reliability in this aspect of evidence given at trial, but the point was not relied upon by those acting for Mr. Lehrmann, presumably because what common sense and the agreed facts go some way to explaining is that a tension or inconsistency of this type must not be dealt with superficially, and there may be an entirely benign explanation for its existence. If Miss Higgins had been the victim of the assault she recounted, this could simply reflect the lability and frailty of memory following such an event, and how someone can come to process trauma and later recount a consolidated memory of a highly distressing incident which has come to dominate her life in recent times. Whatever the truth of what happened, I have little doubt Miss Higgins' current account at trial reflects how I expect she would have wanted to act in such a situation, that is, to demonstrate active and repeated resistance to her assaulter. It's worth recalling her almost ebullient reaction when told the news by Ms. Maiden that Mr. Lehrmann had denied any sex had taken place, where she said, "I thought we were going to have this very nuanced debate about consent and alcohol." There is, of course, no nuanced debate about consent if a woman repeatedly says no and a man proceeds on regardless. Or going back to the words that Miss Higgins used to Mr. Dillaway, there is no need in such circumstances to only feel like what happened was not consensual. There is, however, the real possibility of some nuanced debate if a woman is barely lucid, she later processes what occurred, and she realises she's been assaulted while initially lacking proper awareness of what is going on. I then set out in the process of making findings about what occurred in the ministerial suite, 5 incontrovertible facts. It's worth commencing by identifying 5 facts which are indubitably true, and then draw some logical and direct inferences from those facts. First is that Mr. Lehrmann and Miss Higgins were alone in the ministerial suite for about 40 minutes between 1:48 and 2:38 a.m. Secondly, during this time, Mr. Lehrmann did not answer 6 telephone calls from his girlfriend between 2:16 and 2:18 a.m. Thirdly, at about 2:33 a.m, Mr. Lehrmann departed alone through the security gate and was collected by an Uber. Fourthly, immediately after or shortly after Mr. Lehrmann left, Miss Higgins, having been affected by alcohol, fell into a very deep sleep on the couch in the suite in a state of undress. In this regard, as Mr. Lehrmann accepts in his final submission, Miss Higgins at some time, open quotes, passed out in the minister's suite, close quotes. Fifthly, given no one had seen Miss Higgins leave, it was decided between Mr. Fairweather, Miss Anderson and Mr. Kevin Callan, their supervisor, that Miss Anderson should go up to the minister's office to do a welfare check, which she did, and then at about 4:20 a.m, Miss Anderson entered the suite shouting, "Security, hello security," went to the door of the minister's office and said, "Security, hello security," and there was no answer. 3, opened the door to the minister's office and then saw Miss Higgins lying on her back on the couch in a state of undress, such that she saw Miss Higgins' vagina and Miss Higgins' knees were up and slightly apart. And 4thly, Miss Higgins opened her eyes and looked at Miss Anderson, but proceeded to roll over into the fetal position. I have deliberately used the term state of undress because there is some question as to whether Miss Higgins was fully naked, which I'll resolve below. But with that qualification, all the matters that I've just specified are not in contest. What one can directly infer from these incontrovertible facts is that A, there was sufficient time for Mr. Lehrmann and Miss Higgins to continue to drink whisky together and or to have coitus. B, Miss Higgins was either engaged in sexual intercourse, conduct preparatory to this act, or some other activity between 2:16 and 2:18 a.m, and did not appreciate his girlfriend was calling him, or is aware of calls but ignored them. C, by the end of the 40 minutes, Miss Higgins was sufficiently affected by alcohol not to leave the suite to go home, but in her state had come to be lying naked or semi-naked on the couch. And D, 1 hour and 50 minutes later, Miss Higgins was, although not in obvious distress, sufficiently discombobulated that when seen by a uniformed stranger, she did not interact verbally and did not move immediately to recover her modesty by putting on her dress or covering herself. I now turn to making findings as to Ms Higgins' condition at the critical time, which for reasons I explain in the judgment I regard as being towards the end of the 40-minute period, shortly before Mr Lehrmann left, that is around 2:20 a.m. or thereabouts, or about 2 hours prior to be found by Ms Anderson. The condition of Ms Higgins in the suite. I deal with Dr Robinson's evidence, but then say, despite the efforts of both parties to lend a patina of precision to what in truth is an inherently imprecise exercise based wholly upon assumptions, it's impossible to be certain as to Ms Higgins' blood alcohol content level as of 2:20 a.m. What is far more important than any pinpoint BAC, which we'll never know with certainty, is her general condition, that is, how her level of drunkenness affected her that morning and how I find it would have appeared to Mr Lehrmann. I have already made findings that as early as 4 hours before, Ms Higgins was sufficiently affected such that the CCTV shows her losing balance and stepping backwards to maintain balance, and there are later but less obvious indications recorded on the CCTV of her being less than entirely steady on her feet. CCTV suggests Mr Lehrmann must have been aware of at least one incident of the dock demonstrating a lack of balance, and things then progressed. He knew she was drinking excessively. It was evident to Ms Gain that Ms Higgins was drunk, and I'm satisfied that the same observation would have been made by any sentient person over an extended period. Further and importantly, there is the evidence I accept of Ms Gain that Ms Higgins fell over and Mr Lehrmann helped her back to her feet and into the seating booth. It must have been obvious to anyone that had seen or been party to this incident that alcohol consumption had decreased Ms Higgins' motor coordination. Whatever may have been her precise BAC, she was seriously inebriated. One then comes to the question of what happened in the ministerial suite. Intuitively, given what had been happening, one would think it likely the drinking continued, given what we know about Mr Lehrmann encouraging Ms Higgins to imbibe and the rationale given by him for them to come back to the suite. After all, Mr Lehrmann said he was going to show Ms Higgins whiskey, not Qing Dynasty ceramics. Moreover, very shortly after the incident, before any allegation of sexual assault was made, Ms Lehrmann represented to Ms Brown that he'd come back to drink whiskey and ended up drinking 2 glasses, chatted with Ms Higgins and had drunk whiskey with her. Despite these contemporaneous representations, additional drinking with Ms Higgins in the ministerial suite was not put to Mr Lehrmann in cross-examination because Dr Collins embraced the account given by Ms Higgins as to why she came back to Parliament House, which I have rejected. Ms Wybrow did not put the additional drinking to Ms Higgins because it was the antithesis of his case theory. This is a good illustration of the difficulties with fact-finding when the only 2 witnesses to an event do not tell the whole truth. If I had my druthers, I would have liked to have seen Mr Lehrmann tested on his previous representation as to drinking with Ms Higgins and to hear Ms Higgins' response, but I understand forensically why that was not the case. Although I strongly suspect that additional joint drinking did take place in the ministerial suite, it's unnecessary for me to make a positive finding. There is, of course, other evidences to intoxication, which I'll pass over. There's the important CCTV footage of Ms Higgins entering Parliament House at about 1:45 a.m. and walking through security. Ms Lehrmann submits this demonstrates Ms Higgins A. walked in a straight line through the metal detectors wearing high heels twice, B. bent over multiple times without falling over or stumbling, including once bending from the hip and standing on one foot without any support, C. skipped along the corridor to catch up to Mr Lehrmann, D. smiled and acknowledged someone out of shot and acknowledged a security guard, and E. did not fall over and need to be carried through security. This is all substantially true, but drunk people sometimes walk in a roughly straight line, and it also shows Ms Higgins trying to put her shoes back on, which I presume would not be a complex task, struggling for a considerable period and steadying herself against a security desk. Her difficulty was so obvious that Ms Anderson called out, "Don't worry about it, it's just your shoes." Ms Higgins then gave up trying to put her shoes back on, collected her items from the tray, and then Ms Higgins engaged in the unrestrained behaviour of skipping after Ms Anderson and Mr Lehrmann sans shoes. During her entry, the CCTV footage, taken well over half an hour before what I think is the critical time, demonstrate she was not paralytically drunk and was at this time able to function to a certain level. Consistently with this, the experienced Mr. Fairweather let her in, but understandably, given the nature of his limited observations, he was not able to appreciate how far her cognition had been affected, and in particular how her inhibitions and decision-making capacity had been impaired. Unlike the security guards, but like Ms. Gain on the night, we have an excellent idea of the extent of Miss Higgins' drinking, and taking all the evidence together, by 2:20 a.m. or so, I'm comfortably satisfied that Miss Higgins was a very drunk 24-year-old woman, and her cognitive abilities were significantly impacted. Given this state and the late hour, it is highly likely she was prone to drowsiness. This is strongly supported by the fact, as Miss Higgins put in his final submissions, that she, open quotes, passed out naked in the minister's suite, close quotes, and my findings she was still very significantly affected 2 hours after she was left alone. Further, in the light of my findings as to Mr. Lehrmann's conduct, I'm also satisfied he was aware of her condition. For completeness, I should just note on the reopening there was a contemporaneous note of Assistant Commissioner Close. It is too speculative of nature to have any probative value. No suggestions of this type have been made in evidence and no party has made submissions. I intend to give it no weight and to put a related representation made in the same document out of my mind. Post-incident conduct. It's next worth pausing to check the suggested counterintuitive behaviour pointed to by Mr. Lehrmann that might rationally bear upon what happened in the Minister's office and any other relevant post-incident conduct. In this regard, it is, of course, necessary again to have regard to the agreed facts as to the effect of trauma on recollection. I deal with this, suppose, counterintuitive behaviour and then come to the conclusion I regard this evidence as essentially neutral. The evidence is consistent with a rape not having occurred, but on the assumption Miss Higgins was a victim, this reaction does not offend common sense. I have already explained why it was unnecessary for me to accept opinion evidence, explaining the danger of making assumptions as to the reliability of sexual assault complaints by reason of some a priori view as to how victims of sexual assault are expected to behave. Reasoning based on so-called typical behaviour of genuine victims, such as shunning or exhibiting hostile behaviours towards the perpetrator or avoiding contact is superficial and distorts the process of fact-finding. In considering the validity of Miss Higgins' allegations, I do not consider Miss Higgins' actions in accepting a cup of coffee or responding to emails about news alerts or requesting Miss Higgins' professional help as important. They are consistent with there not being any issue between them, but again, on the assumption she was a victim, they can be readily characterised as the actions of a woman who had not yet come to terms with what had happened to her, but needed to confront the reality that she had work out a way of being in the same professional office as a male colleague who had assaulted her. No doubt the struggle to work out how she would respond would resonate with many women working in any type of workplace who have had to find some way of coping with such a predicament. I have little doubt that if she had been raped, that by the time of these interactions, it's quite conceivable that Miss Higgins would be driven by conflicting emotions, self-doubt, concern she would be humiliated by word leaking out to her colleagues and questioning the prudence of her behaviour. Moreover, these incidents cannot be assessed in a vacuum. It's also necessary to have regard to the fact of the other contemporaneous actions of Miss Higgins that are consistent with her being a victim of sexual assault. I've already made reference to her important contemporaneous representations to Miss Payne, Miss Dillaway and Major Irvine, which I set out. There are all similar representations. There was Miss Higgins' message to Mr O'Connor, the Queensland MP and friend of Miss Higgins, on 29 March 2019, where she represented that a super fucked up thing had happened a little while ago, and there was a subsequent telephone conversation during which rape was mentioned. There was some, I think, relatively insignificant evidence of change of demeanour. There was the open quotes, reaching out, close quotes, to the PMO suggested by Mr Dillaway, which was accepted by Miss Higgins. This, of course, does not prove a rape occurred, but a person in the position of Miss Higgins agreeing for a friend to reach out to the PMO in relation to matters relevant to the incident is not behaviour counterintuitive to a sexual assault having occurred. Finally was a representation made to her father which falls into a somewhat different category because it occurred much later. Mr. Higgins gave raw and palpably believable evidence that after a trip to Canberra in March 2019, he did not hear from his daughter and felt something was wrong. He then explained on 2 February 2020 his daughter sent him a message and he responded. One of those responses that Ms. Higgins told him that she had been raped. Again, this sort of statement must be put in proper context, but one wonders why a daughter would say such a thing to a clearly loving father absent a genuine belief that sexual assault had taken place. For completeness, it's worth stressing these apparently candid communications with her father might be thought to have cogency because they occurred before the person later charged with the responsibility of preaching the project of a cover-up, Mr. Shiraz, came into her life on 29 May 2020 and the important Four Corners program and the subsequent development of the cover-up narrative took place. A further aspect of Ms. Higgins' post-incident behaviour said by Mr. Lehrmann to be a powerful evidence that Ms. Higgins knew no sexual activity had taken place was the failure to have a sexually transmitted infection check performed, despite telling Mr. Dillaway she was doing so, and her evidence she believed Mr. Lehrmann had, open quotes, finished inside her, close quotes. I reject this submission. It suggests a pattern of typical or normal behaviour of rape victims that takes insufficient account of the agreed facts as the possible effects of trauma and the variability of reaction sexual trauma can cause. There may be many reasons on the assumption Ms. Higgins was a victim of rape for her not wanting to subject herself to such a process, particularly when the surrounding contemporaneous material suggests she had no intention of pursuing a complaint with the police at this time. In summary, despite other concerns as to her creditworthiness, any alleged post-incident counterintuitive behaviour of Ms. Higgins does not materially affect the assessment of the underlying cogency of her allegations she was consulted. I should make the further point that this is a civil case. Section 66(2) of the Evidence Act doesn't apply, and the contemporaneous representations, prior consistent evidence and complaints made to Ms. Brown, Ms. Payne, Ms. Dillaway, Major Irvine, Mr. O'Connor, and we'll see the AFP on 1 April, go beyond merely putting other post-incident conduct in a proper context, but can be used to show consistency of conduct by Ms. Higgins, some proof that what was exerted in the representations. In this way, the previous representations are relevant to the reliability of Ms. Higgins in this aspect of the case. None of that evidence was the subject of a Section 136 limitation on its use. As can be seen, I have A, directed myself as to the principal approach to fact-finding, B, identified why, on the basis of my credibility assessments and other reliable contemporaneous evidence, 1, I reject entirely Mr. Lehrmann's account of what happened in the ministerial suite, and 2, have identified aspects of the account of Ms. Higgins that are inaccurately based or exhibit an apparent inconsistency. C, made findings to 1, the condition of Ms. Higgins, and 2, the preceding proximate interactions between Ms. Lehrmann and Ms. Higgins and their states of mind when they arrived at Parliament House. D, identified incontrovertible facts and drawn some conclusions from the existence of those facts, and E, considered any alleged counterintuitive behaviour and relevant post-incident representations. Against this background and the context of my other conclusions, I now come to identifying what happened within the ministerial suite. In doing so, I will distinguish between something that might have happened, but where I'm unable to reach a sufficient level of satisfaction to allow a finding of fact to be made, and something which, on the balance of probabilities, did happen, where I've reached the requisite level of satisfaction to make a finding of fact. As to the former, it is possible, for example, that Ms. Lehrmann left Ms. Higgins on the office ledge for a period, as she asserts, but only while he obtained his whisky and glasses and was ready to usher her into the minister's office, but I cannot be satisfied that this was the case. Although I suspect Miss Higgins was telling the truth about being on the ledge for some short period, it's also possible they both entered the minister's office and immediately started drinking. But again, I've not reached the requisite level of satisfaction. Whatever the true position as to additional drinking, I am convinced, however, that sexual intercourse did take place, and it took place with Mr. Lehrmann on top of Miss Higgins on the couch in the minister's office. I will come back to whether I accept Miss Higgins' evidence that she was not aware of what was happening when Mr. Lehrmann commits the sexual act. I am also amply satisfied, in accordance with the inherent probabilities, that coitus and any other physical conduct concluded quickly upon Mr. Lehrmann ejaculating, and that he thereafter promptly left the minister's office and the ministerial suite. it follows that it's far more likely than not that sexual intercourse occurred towards the end of the period when both Mr. Lehrmann and Miss Higgins were in the minister's office at around or shortly after the time Mr. Lehrmann's girlfriend was trying to telephone him. Given the evidence I've already discussed and the weight I place on contemporaneous representations, I have not reached the level of satisfaction that during the sexual act, Miss Higgins said no in a loop, and I think it's more likely than not that she did not or was not able to articulate anything. On balance, I think it is more likely than not that she was passive, as she later said, like a log during the entirety of the sexual act. I'm further satisfied that she felt unable to get out from the couch immediately following Mr. Lehrmann leaving, and that she then passed into a deep sleep. The fact she, open quotes, passed out, close quotes, at some time is common ground in final submissions. When it comes to the dress, I accept the evidence of Miss Anderson, who encountered her about 2 hours later. It's unclear to me whether the dress had been completely removed prior to the sexual act or during it, or had just been scrunched around the waist of Miss Higgins, thus exposing her breasts and genitalia. If it was the latter, I think it is likely the dress was taken off by Miss Higgins at some time prior to the arrival of Miss Anderson, despite her not being fully aware of her surroundings, presumably to allow her to be unencumbered by it while sleeping. As to the bruise, I feel well short of being satisfied that Mr. Lehrmann placed his leg against either of Miss Higgins' legs so forcibly as to cause a large bruise, particularly given my considerable doubts about the authenticity of the bruise photograph. I'll make some further findings as to what occurred when I shortly come to consider the elements of rape. What needs to be proven in the Section 25 defence is whether there was a rape. Network 10 contends that because Mr. Lehrmann denied any sexual contact took place, this obviated the need for any inquiry to take place as to whether intercourse described by Miss Higgins would have been consensual, or as to whether the conduct was other than willful or reckless. See Crimes Act 1900 Section 54. If intercourse occurred as described by Miss Higgins, it was obviously rape. But it is not as easy as that for two reasons. First, as I've explained, although I have found intercourse took place, I'm not reasonably satisfied as to an aspect of the account of Miss Higgins as to what occurred. That is, she repeatedly expressly said to Mr. Lehrmann that he should stop. And secondly, the relevant inquiry on a substantial truth defence is not governed by whether Mr. Lehrmann breached a particular statutory norm, being Section 54(1) of the Crimes Act. This second point requires some elaboration. It is agreed the respondents must prove that Mr. Lehrmann raped Miss Higgins, but what does one mean by rape in this context? Does it mean something different from what can be described as the penetrative sexual offence that existed in ACT at the time of the alleged assent, or at the time of publication? Put another way, does it mean something different from the charge Mr. Lehrmann faced in the criminal proceeding? Historically, rape was defined at common law as carnal knowledge by a man of a woman who was not the man's wife against her will. Consistently with this definition, the crime of rape required proof of physical force and resistance. Further, the crime was subject to a narrow definition of sexual intercourse, and as the years passed, statutory extensions and modifications to the common law claim of rape have been made in all jurisdictions to varying degrees. For example, there's no longer any principle of Australian common law respecting the single personality of spouses, hence rape can occur within marriage, and the penetrative sexual offence is no longer gender specific, and despite some inconsistencies generally includes penetration of the genitalia by a penis, object or part of body or mouth. There has now been removal of express references to force and the introduction of a consent standard based on voluntary agreement. Further, the penetrative sexual offence is still described in rape in some jurisdictions and as different things in other places. It may be stating the obvious, but given some submissions made by the parties, it's important to stress that I'm not dealing by whether, by reference to the civil standard of proof, Mr. Lehrmann has breached a specific criminal provision under the law of the Australian Capital Territory. My inquiry is different and is relatively focused on the natural and ordinary meaning of the word rape. Moreover, it must be borne in mind that language is not static. It evolves, and a word's detonation and connotation is not immune from development and change. Our focus is on what rape means in contemporary Australia, not by reference to what it may have meant historically or may mean in the future if, for example, legislative change eventually causes the ordinary perception of what constitutes consent to also change. Although the elements of the penetrative sexual offence can differ somewhat between jurisdictions and by reference to the time when the offending is alleged to have taken place, in my view, the natural and ordinary meaning of rape is tolerably plain. As noted above, given the contemporary ordinary understanding of rape and how it's particularised in this case, the respondents are required to prove 1. That at the time of the place alleged, that is at Parliament House on 23 March 2019, Mr Lehrmann had sexual intercourse with Ms Higgins. 2, without Ms Higgins' consent, and 3, knowing Ms Higgins did not consent. I've already explained how I consider the respondents have made out the first element. Network 10 deals with the non-consent element and the knowledge element briefly and simply relies on the fact that Mr Lehrmann said he did not at any stage seek to procure consent to have sexual intercourse with Ms Higgins. It then says that because Mr Lehrmann knew that Ms Higgins had at least 6 spirit-based drinks at the dock and then several further drinks at 88 mph, that his conduct in respect of consent to intercourse was at least reckless. Ms Wilkinson oddly submits that with regard to the non-consent element, that Ms Higgins gave evidence she did not consent to have sex with Ms Lehrmann, and this should be accepted because she was not challenged on that evidence. More logically, she also submits that by reason of the toxicology evidence, the court should find that Ms Higgins was incapable of consent due to her level of intoxication. Ms Wilkinson then tends to elide the last 2 elements by submitting that even if I was to reject the evidence as to Ms Higgins' protestations, 1, if the sexual intercourse had been consensual, it is likely that Ms Higgins and Mr Lehrmann would have left together, but Mr Lehrmann leaving her there semi-lucid is indicative of his knowledge that Ms Lehrmann did not consent to what have taken place. And 2, Mr Lehrmann had knowledge of Ms Higgins' lack of consent by the fact he observed her drinking heavily throughout the night, saw her fall over and observed her going through security and being unable to put on her shoes. Before setting out my reason to each element, which ought to be considered separately, it's convenient to first consider and then reject the notion that if consensual sex took place, then it is likely Ms Higgins and Mr Lehrmann would have left together. I do not consider this logic to be at all compelling. This is because on the assumption the sex was consensual, Mr Lehrmann was still behaving dishonourably by having sexual intercourse with Ms Higgins while in a relationship and while his girlfriend was trying to contact him, presumably trying to work out where he was and why he was there at 2:15 a.m. Given he'd satisfied himself and that he knew his girlfriend was awake and attempting to contact him, calling an Uber and getting out of the ministerial's private office with celerity and leaving Miss Higgins undress is the actions of a cad, but is nonetheless explicable. That argument can be put to one side. I now turn to the issues of more substance and proceed to deal with the question of whether the respondents have discharged their burden on the balance of probabilities of proving the second element, non-consent element, and then separately deal with the third element, knowledge element, non-consent element. Unlike the first element, the second element obviously enough concerns Ms Higgins' state of mind. Although I am not satisfied there was a clear verbal protest being made by Miss Higgins and find it more likely that Miss Higgins was passive during the sexual act, any suggestion that some form of active resistance is determinative of the question of consent would be misguided. Ordinary human experience suggests that sexual assault victims vary in their behaviour, including during a sexual assault. The notion a woman is expected to either fight or flight to be accepted as having been a victim of sexual assault is not only not reasonably open but wrong-headed. It is redolent of historical conceptions of rape which relied upon notions of force and resistance rather than the contemporary focus on voluntary consent. This is not to suggest that in order to conclude there is a want of consent it is appropriate I have regard to, let alone form a considered view about, the extensive empirical studies of persons alleging sexual assault and the voluminous academic literature not referred to by any party as to how humans exposed to extreme threats may react with disassociation or a state of involuntary temporary motor inhibition known as tonic immobility, and the suggested widespread phenomenon of the occurrence of tonic immobility during sexual assaults. I am not to rely on matters not in evidence. What I am required to, in applying the fact-finding principles I have explained, the facts found and agreed and common sense, is to assess the reliability of Miss Higgins' evidence as to her state of mind. That is, she did not consent because she was so drunk on the couch that at some point she was not aware of her surroundings and then suddenly became aware of Mr. Lehrmann being on top of her, at which time he was performing the sexual act, which he then continued to a conclusion. In evaluating the cogency of this aspect of her evidence, I'm required to have regard to all the evidence, including contemporaneous representations made by Miss Higgins shortly after the incident, and to a number of other matters, including mandatory considerations reflecting the necessity to approach the allegation with much care and caution, and with weight being given to the presumption of innocence and the exactness of proof required. The other fact-finding principles are referred to the judgment, including but not limited to the need for me to reach a state of reasonable satisfaction on the preponderance of probabilities, the care required where there are a range of possibilities open, and the only way one reaches a state of reasonable satisfaction as to one being proven is to conclude its existence as more likely than all the other hypotheses available on the evidence, and see that witnesses may be untruthful about some things and yet be truthful about others. And thirdly, Miss Higgins' general lack of creditworthiness and the heightened caution therefore necessary in assessing any aspect of her evidence, and more particularly the fact I have not accepted she expressly and repeatedly voiced her lack of consent. But in the end, it comes down to my assessment of whether Miss Higgins was telling the truth in the witness box when she gave this evidence as to her state of mind, having paid close attention to not only what was said, but her manner of saying it. Notwithstanding the cautions to which I have referred, the full range of other possibilities combined, and taking all my reservations as to the credibility and reliability of Miss Higgins into account, her evidence that she was not fully aware of her surroundings, but then suddenly became aware of Mr. Lehrmann on top of her, at which time he was performing the sexual act, when given orally before me, struck me forcibly as being credible and having the ring of truth. I use the term fully aware advisedly, as consciousness is best understood as not being a binary concept but rather being on a continuum, and the evidence defies a finding as to her precise state of confidence at the specific time. In accepting this specific aspect of Miss Higgins' evidence, I have directed myself to bear in mind that, like in any case where criminal conduct is sought to be proven based largely or exclusively on a single witness, it is important I am satisfied to the appropriate standard that the witness is both honest and accurate in the account given. I have also been conscious of the dangers of too readily drawing conclusions about truthfulness and reliability based on the appearance or demeanour of a witness while giving evidence. It is for this reason I have tried as best I can to limit my reliance on the appearances of witnesses and have attempted to reason my conclusions as far as possible based upon contemporary materials, objectively established facts, and the apparent logic of events. But there is nothing about this finding that conflicts with the objectively established facts or logic, and indeed when one has regards to the other events of the night and Miss Higgins' immediate post-incident conduct taken as a whole, including the consistency of her core allegation of sexual assault, the opposite is true. At the risk of repetition, I am conscious of the fact that I must eschew exact proofs, indefinite testimony or indirect inferences, and in doing so, I'm acutely aware that working out when a compromised witness such as Miss Higgins is telling the truth in one aspect of her evidence presents real challenges. But bearing all these matters in mind, I have reached a state of actual persuasion on the balance of probabilities that Miss Higgins A. was not fully aware of her surroundings when sexual intercourse commenced, and B. did not consent to intercourse when she became aware Miss Lehrmann was on top of her. The non-consent element is made out, the knowledge element. The third element also involves consideration of state of mind, but this time of Mr. Lehrmann. If one accepts sexual intercourse happened, and also accepts that Miss Higgins did not consent to intercourse as I have found, the issue arises as to whether one can draw the inference that Mr. Lehrmann must have known that Miss Higgins was not consenting. If I was to accept that Miss Higgins was obviously unconscious when sexual intercourse commenced, then proof of the knowledge element would follow readily. That may well have been the case, but it is equally probable this may not have been obvious, thus requiring focus on the issue as to whether Miss Lehrmann understood that Miss Higgins, in her inebriated state, was not fully aware of what was happening to her. Given what I found it being likely Miss Higgins did not expressly voice her resistance, and the other findings I've made of the interactions, that Miss Higgins was like a log opening and close inverted commas, I do not consider I can be positively satisfied on the balance of probabilities that Mr. Lehrmann turned his mind to consent and had at the relevant time a state of mind of actual cognitive awareness that Miss Higgins did not consent to having sex. But this is not the end of the matter. It is not in dispute that the knowledge element can be established by recklessness, and Mr. Lehrmann, in closing submission when dealing with differences between imputations, accepts that the bare fact of rape might be committed simply by being recklessly indifferent to whether or not there was consent. Much ink has been spilled and significant attention of law reformers and legislators has been directed in recent years to the issue of what constitutes recklessness as it relates to the fault element in sexual offences. Although this topic, for reasons I have explained, was wholly unexplored in the submissions and the parties have not engaged with the question as to what recklessness means having regard to the ordinary contemporary conception of rape. Recklessness can, of course, mean different things, such as an awareness the complainant might not be consenting, possibly recklessness, indifference as to whether the complainant is consenting, indifferent recklessness, and failure to give any thought as to whether the complainant is consenting, inadvertent recklessness, although possibly recklessness might best be seen as a variant of indifferent recklessness. This sort of taxonomy can distract, and in any event, it is sufficient for our purposes to consider what has been usefully called in the cases non-advertent recklessness. After considering the authorities and considering the ordinary conception of rape, I consider the knowledge element can be established if the respondents prove to the civil standard that at the time sexual intercourse took place, Mr. Lehrmann's state of mind was such that he was indifferent to Miss Higgins' consent and just went ahead willy-nilly. Put another way, the knowledge element is established if Mr. Lehrmann was so indifferent to the rights of Miss Higgins as to ignore the requirement of consent. I will not repeat what I have set out in the preceding section. Needless to say, like with my findings as to the other two elements, I have again reminded myself of the principles I've explained as to fact-finding, the need to feel an actual persuasion of the existence of a fact, the seriousness of the allegation of knowledge of non-consent, and the extent of the unlikelihood, and separately the gravity of the consequences flowing from the finding. Notwithstanding the need for pause, I am satisfied that it is more likely than not that Mr. Lehrmann's state of mind was such that he was so intent upon gratification to be indifferent to Miss Higgins' consent, and hence went ahead with sexual intercourse without caring whether she consented. This conclusion is not mandated by, but is consistent with my finding that intercourse commenced when Miss Higgins was not fully cognitively aware of what was happening. In summary, I consider it more likely than not in those early hours, after a long night of conviviality and drinking, and having successfully brought Miss Higgins back to a secluded place, Mr. Lehrmann was hell-bent on having sex with a woman he A, found sexually attractive, B, had been mutually passionately kissing and touching, C, had encouraged to drink, and D, knew had reduced inhibitions because she was very drunk. In his pursuit of gratification, he did not care one way or the other whether Miss Higgins understood or agreed to what was going on. Because of what I find to be Mr. Lehrmann's state of mind of non-advertent recklessness, the knowledge element has been made out. For completeness, I note in reaching this conclusion I have fully considered all the submissions made by Mr. Lehrmann include one his counsel described as critical. It is worth making 3 short points as to aspects of Mr. Lehrmann's submissions to the extent I have not otherwise dealt with them. First, the important corroborative evidence of Ms. Anderson is minimised by asserting her observations as the state of Miss Higgins' makeup created difficulty for the respondents, and although Miss Higgins was found asleep on the couch naked, this because it would simply made her more comfortable, as she decided to remove her dress before she lay down on the couch, as she may have wanted or tried to avoid vomiting on her dress and then passed out asleep. I do not regard these submissions as being in the least persuasive. Miss Anderson's fleeting observations upon being confronted by the surprising sight of Miss Higgins looking up at her, not in obvious distress, but being sufficiently unaware of her surroundings to just stir herself to turn over into the fetal position like a naked newborn babe, are highly likely to have precision as to such a minor matter. In any event, without getting into the vulgarities, common sense suggests the sort of sexual activity I find took place would not necessarily result in a woman's makeup being smeared all over her face, as the submission implicitly suggests. As to the point of the dress, ingenuity may be able to conjure up any number of possibilities short of a frock just falling off, but we are here dealing with questions of likelihood, which leads to the next more general and so-called critical point. Mr. Lehrmann points to another of plausible explanations. Between the two polls advanced by Mr. Lehrmann and Ms. Higgins as to what happened are a range of possibilities, which Mr. Lehrmann points to and submits as necessary to consider these scenarios. Without repeating them, all these scenarios have been considered and some rank higher in the likelihood range than others. For example, scenarios that consensual sex occurred or Mr. Lehrmann was not reckless while having non-consensual sex are more likely than scenarios they just passed and drank whiskey and Miss Higgins later decided to take her clothes off for a lark, or because she was feeling close or had a fit of the vapours, or that Miss Higgins prepared herself to have sex by lying down but fell asleep and Mr. Lehrmann departed because of scruples as to not taking advantage of the otherwise willing Miss Higgins. Whether they are fanciful or just unpersuasive, they are all individually far less likely eventualities than what I found took place. Further, and critically upon a review of the whole of my findings on the evidence, even taking all these other possibilities of what might have occurred together, the sum of the likelihood they occurred is outweighed by the likelihood Miss Higgins was raped, as she asserted in the critical part of her oral testimony towards me. There was also a suggestion about Miss Higgins' motive to lie, which I deal with. My conclusion on rape: Miss Higgins raped, Mr. Lehrmann raped Miss Higgins. I hasten to stress this is a finding on the balance of probabilities. This finding should not be misconstrued or mischaracterised as a finding that I can exclude all reasonable hypotheses consistent with innocence. As I've explained, there's a substantive difference between the criminal standard of proof and the civil standard of proof, and as a tribunal of fact, I have only to be reasonably satisfied that Mr. Lehrmann has acted as I have found, and I am not obliged to reach that degree of certainty necessary to support conviction on a criminal charge. In my reasons, I make a very large number of findings concerning relevant post-incident conduct, which are relevant to the conduct of the credit of Ms. Higgins and also in some respects to other aspects of the case, but I do not propose to recount them here. I also deal with the question of damages on the basis that I have failed in order to properly discharge my duty in determining the substantial truth defence. In determining the counterfactual damages, I say the theoretical complications that sometimes arise are absent here. The choice of a counterfactual for the purposes of assessing damages is relatively straightforward. I will only deal with a more realistic choice given my findings and legal consequences that flow from those findings. That is, I will not address a fantasy world where Mr. Lehrmann is to be believed on his French submarine fiction, but the more realistic scenario where sex took place, but I ought not to have found that the non-consent and or the truth and or the knowledge elements were established by the respondent, so I had to make out the substantial truth defence. In doing so, I deal with matters relevant to aggravated damages. There are a number of bases pressed. I do believe that one matter relating to aggravated damages was amply made out: the Logie speech and Ms. Smithy's advice. Ms. Smithy's gave evidence she considered it was her role, not that of Mr. Drumgold, to give advice about the proposed Logie speech to Ms. Wilkinson. This was an understandable view, but it was not strictly accurate. As Acting Justice Kay explained in Drumgold on Board of Inquiry No. 3, it is a fundamental principle that a prosecutor, as a Minister for Justice, has an obligation to ensure a trial is conducted in accordance with the dictates of fairness to an accused person, and to ensure that the integrity of the trial is appropriately preserved. As Ms. Smithies was correct in appreciating, however, as a solicitor accompanied Ms. Wilkins, she owed an independent duty to give Ms. Wilkinson appropriate legal advice. Ms. Smithies is well qualified to give that advice. She's a highly experienced solicitor of the Supreme Court of New South Wales of about 27 years standing and has been the Chief Litigation Counsel of Network 10 for 10 years. Since 1999, her duties have included providing pre-publication and broadcast advice to media companies, initially in her role at Gilbert and Tobin and then at Nine Entertainment Co, Australian Associated Press, and currently at Network 10. She reports to Mr. Stuart Thomas, who holds the curious title to Australian ears of Vice President, Legal and Corporate Affairs for Network 10, and works with the, open quotes, primary lawyer, close quotes, being the senior legal counsel of Network 10, Mr. Farley. At the conclusion of the evidence of Ms. Smithies, I sought to clarify and summarise Ms. Smithies' evidence about the Logie speech and her related advice given to Ms. Wilkinson. Ms. Smithies gave the important evidence which I set out in the judgment as to her state of mind. I conclude from this evidence and from her other evidence that Ms. Smithies not only turned her mind to the issue of whether Ms. Wilkinson should give the speech in terms it was given, but it was also apparent she, one, actively considered how the content of representations made by Ms. Wilkinson may or may not be prejudicial to the assessment of the credit of Ms. Higgins in the pending criminal trial, and two, gave the advice in order to ensure Ms. Higgins' credibility was not undermined by speculation Ms. Wilkinson was wavering her belief as to the truth of the accusation of rape. At the very least, she must have known this speech, when broadcast in the ACT, would involve a prominent figure just endorsing a claim by her professional peers, making comments relevant to the guilt of an accused when he was facing an imminent jury trial for a serious offence, exposing him to the prospect of a significant jail sentence, being a trial in which the prominent figure who was proposed to be called in the Crown case. She also knew that the speech amounted to, open quotes, endorsing the credibility of the complainant, close quotes, and was, open quotes, lending credence to the representation of a complainant as a woman whose story must be believed, close quotes. For reasons which defy common sense, Ms. Smithies thought Ms. Wilkinson faced a binary choice: to continue to endorse the credibility of the complainant in a pending sexual assault trial, or to act in a way that would be perceived as wavering and supporting her credibility. It appears it did not occur to her there was another obvious and more responsible option, merely saying thank you or making an anodyne speech which did not say such things as "the truth is this honour belongs to Brittany," and having a network star and witness endorse the complainant's unwavering courage in accusing Mr. Lehrmann of rape. As an experienced media lawyer, Ms. Smithies should have been alive to the concept of sub judice contempt of court, and that it can occur when a publication, as a matter of practical reality, tends to interfere with the course of justice in a particular case. When the balloon went up following the speech, leading to the Chief Justice making findings as a significant prejudice occasioned by representations going to the credibility of the complainant being so widely reported so close to the impanelment of the jury, it is little wonder that Ms. Smithies and Network 10 became very concerned about contempt. It's also unsurprising the thought was given to limiting the perceived damage, including by consideration being given not to appearing in court to proffer an apology, and advice being taken from experienced senior counsel who had publicly remarked the speech was ill-advised as to how to best mollify the evident concern of the Chief Justice. The approach taken by Network 10 was then carefully considered and resulted in a letter being sent to her honest associate, which, although using words such as, open quotes, profound regret, close quotes, and, open quotes, apology, close quotes, when closely parsed, is directed at regret for the consequences that ensued and not the fact the speech was given. According to Ms. Smithies, it amounted to an apology for things for which Network 10 bore no responsibility. It was not disclosed to the Chief Justice that Ms. Wilkinson gave the speech based on considered advice, nor was it given for the specific purpose now explained by Ms. Smithies, and that Network 10's Chief Litigation Counsel continued to stand by the appropriateness of the giving and content of the speech. The conduct of Network 10 through its employees in procuring Ms. Wilkinson to give the speech in the form it was given for the reasons it was given was grossly improper and unjustifiable. It was conduct apt to cause disruption of the criminal justice system, and without the Chief Justice making the orders she did, could have imperilled Mr. Lehrmann's right to a fair trial. I then deal with various submissions made about these points, including rejecting some what I regard as wholly misconceived submissions made by Ms. Wilkinson concerning it. And I find I do not accept the implicit premise in the submission now advanced by Ms. Wilkinson on the basis of, open quotes, unchallenged, close quotes, evidence that she was somehow vexed and reticent in making the speech upon receiving the award at the Logies, and she was placed in the invidious position of balancing her concern with her obligations to comply with lawful directions by her employer. The notion of a reluctant Miss Wilkinson being forced by her employer to make the speech does not ring true at all. Although I regard Ms Wilkinson's conduct giving the speech to be improper and justifiable, she has less culpability than those encouraging her to make the speech. Ms Wilkinson at least had the insight to seek advice and might not be expected to have the objectivity of others within Network 10, given the fact that she had, as Ms Smithies noted, become part of the story. Although these findings are sufficient for the purpose of identifying the actual and attributed conduct of the respondents as an aggravating circumstance, I cannot responsibly leave this topic without remarking that the most disturbing aspect of this part of the case is the insouciance of Ms Smithies as to the real criticisms made by the Chief Justice and the repeated fastening upon Mr Drumgold's separate failure as some form of excuse. There's been ample time for mature reflection, and yet there is no recognition, even now, that the speech could have undermined the administration of justice and caused it to be disrupted. It is one thing to make a mistake, even a serious mistake. After all, to err is to be human. But I regret to say the continuing lack of insight of Ms Smithies as to the inappropriateness of her conduct related to the speech reflects, in my view, a lack of proper appreciation of her professional obligations as a solicitor and her paramount duty to the court and the administration of justice. See Rule 3, Legal Profession Uniform Australian Solicitors Conduct Rules. I then deal with the issues such as severity, hurt to feelings and damage to reputation. As regard to severity, it speaks for itself. As to hurt to reputation, after having the opportunity of observing Mr Lehrmann giving evidence, it seemed to me that where his real hurt emerged is when he gave evidence as to the conduct of others that had prejudiced his ability to have a fair trial. To the disinterested observer conscious of the importance of the rule of law, his white-hot anger as to his right to a fair trial and the presumption of innocence being undermined by persons presuming his criminal guilt and then exercising their conjecture publicly before the allegation was tested, and later when it was no longer to be tested in the criminal justice system, is perfectly understandable. But from my observation, this reaction seemed to be qualitatively different to the evidence he gave as to his subjective reaction to the publication of the imputations as to the underlying allegation of rape. This is likely to do with the fact that on the premise I'm calculating damages, he well knew that he had sex with Miss Higgins, which gave rise to at least some questions as to consent, remembering you were presently dealing with a counterfactual. I also deal with problems concerning the causation relating to damages, the minor extent of publication. And as to aggravated damages, although I find that there is a basis for aggravated damages, it doesn't follow axiomatically that this conclusion would have led to any augmentation of the damages paid by Mr Lehrmann. I'm prevented from awarding exemplary damages. And in relation to aggravated damages, a complication arises. Aggravated damages are a form of compensatory damages, and although he was initially extremely distressed and hurt by the conduct of the respondents in undermining his right to a fair trial, or seeking to, or having engaged in conduct that was apt to, I should say, this only lasted for a short period and has had no ongoing effect. Mr Lehrmann gave evidence and became evident soon after the speech that Ms Wilkinson ironically did him a favour by making the Logie's speech. Mr Lehrmann would have been entitled to more than a nominal award for reasons I explain, but as the analysis in the judgment illustrates, his award of ordinary compensatory damages would be very modest. Hence, any augmentation of damages occasioned by the aggravating conduct comes from a very low base. If it had been necessary to assess damages in favour of Mr Lehrmann, the appropriate and rational relationship between the actual harm sustained and the damages awarded would lead to total damages of $20,000. Conclusion. Having escaped the lion's den, Mr Lehrmann made the mistake of coming back for his hat. As I stressed at the commencement of these reasons, there is a substantive difference between the criminal and civil standards of proof. To make the grave finding Mr Lehrmann raped Miss Higgins, it's unnecessary for me to reach the level of certainty indispensable for criminal liability. The respondents have not won because I can exclude all other possibilities as to what happened, but because they have proven that such possibilities that are open on the evidence, both individually and collectively, are unlikely, and further because I am satisfied that the evidence provides an appropriate basis upon which to reach a conclusion. Put another way, they have proven that the whole of the evidence properly analysed establishes a reasonable satisfaction on the preponderance of probabilities of facts sufficient to make out the substantial truth defence. As a result of the inconclusive criminal trial, Mr Lehrmann remains a man who has not been convicted of any offence, but he is now being found by the civil standard of proof to have engaged in a great wrong, it follows Miss Higgins has been proven to be a victim of of sexual assault. At first glance, this might be thought to be an odd outcome, but if one leaves aside superficial reactions and appreciates the high value the common law has always placed upon the importance of securing against the conviction of the innocent, it is not at all peculiar. Ensuring an accused is deprived of their liberty only if a prosecution can exclude all reasonable hypothesis consistent with innocence has been as elemental to our criminal justice system as the presumption of innocence and the related golden thread running through the criminal law that the prosecution bears the burden of proof. Mr. Lehrmann is not entitled to the vindication of his reputation. The respondents, however, are entitled to vindication by the entry of judgment on the statement of claim. But even though the respondents have legally justified their imputation of rape, this does not mean that their conduct was justified in any broader or colloquial sense. The contemporaneous documents and the broadcast itself demonstrate the allegation of rape was a minor theme and the allegation of cover-up was the major motif. The publication of accusations of corrupt conduct in putting up roadblocks and forcing a rape victim to choose between her career and justice may have won the project team like Miss Maiden a glittering prize, but when the exact accusation is examined properly, it was supposition without reasonable foundation in verifiable fact. Its dissemination caused a broom of confusion, and it did much collateral damage, including to the fair and orderly progress of the underlying allegation of sexual assault through the criminal justice system. To the extent that there were perceived systemic issues as to avenues of complaint and support services in Parliament, this may have merited a form of fact-based critique, not the publication of insufficiently scrutinised and factually misconceived conjecture. I will direct an outline of submissions on costs be filed, and then we'll list the matter to hear and determine all outstanding issues, including the residuum of issues arising on the cross-claim. And I make the following orders. 1. Judgment for the respondents on the statement of claim. 2. The parties file submissions as to the costs order for which they contend, and any evidence they rely upon in relation to costs on or by 22 April 2024. I publish my reasons. Adjourn the court.